नहीं ऊपर नहीं जाता है अच्छा ठीक है
May I please?
Yes, I hope not many adjournments.
Lordship, I beg to mention item number 26. Here the leading counsel is indisposed. So if this matter can be listed after 2 weeks,
Indisposed.
yes, Lordship.
Hmm. Where is he? Where is he? Where is the council?
This is indisposed. Lordship.
Indisposed where?
This is out of station.
Huh?
This is out of station. that's
Out of
why.
station. Okay. Right. On the prayer for adjournment made on behalf of the petitioners council, list the matter after 2 weeks.
So
Yes,
please,
Lordship.
I beg to mention item
Yeah,
number
well-
15, Your Lordship.
Just call just give me that seat. Just very low. Yes.
I'd like to mention item number 15, Lordship.
15.
To file my affidavit in opposition, Lordship. 3 weeks' time may be granted.
Item 15.
Yes, Your Lordship. To file my affidavit in opposition, Lordship.
Okay. Miss
MT Lapungan.
MT,
MT Lapungan.
not here. Your name is not here. Huh?
Respondent, Your Lordship. Respondent number 6.
Acha, acha, okay. Number 6. No, your name is not here, no? In the causes?
It's there, Your Lordship. MT Lapungan.
Oh, Imtila Pongan.
Yes,
Okay,
Your
okay,
Lordship.
okay, okay. Miss, on the prayer made by Miss Imtila Pongan, Learned Counsel for the respondent number 6, who submits that she would like how much time?
3 weeks' time, Your Lordship.
3 weeks time to
Yes,
file
sir.
a affidavit in the position. This is the matter of the 3 weeks.
Much obliged.
Lordship, I beg to mention item number 23 and 24, Lordship.
23 and 24. Well, if you are going to adjourn all the matters.
If this matter may be taken up on Thursday, Lordship, on 20, Lordship. I have some difficulties today, Lordship.
Who's for the other side?
Lordship, I'm appearing for respondent number 10.
Any objection?
No, Lordship.
But
Taken,
yes,
taken.
yes, so we can take it up on Thursday.
Yes, ma'am.
Lordship.
No adjournment,
Lordship.
no adjournment. Oh, no.
It's a consensus
let-
prayer,
You
Lordship.
see, there's no point adjourning a matter for adjournment.
Lordship.
On Thursday.
Okay, right. On the prayer of the parties, list the matter on Thursday. Right. The matter relates to the acquisition of land without taking recourse to the land acquisition laws applicable. Full stop. On the other hand, it is the case of the respondents that the village council had agreed that no compensation would be claimed by the village. Full stop. The petitioner, who is a landholder, has however made a claim for the same. Were you present at the time? You're the petitioner.
Yes, Lordship.
Were you present at the time when the village council gave the undertaking?
No, Lordship.
You're not present.
No.
Not me. Why isn't the village council a party here? Do they? Huh?
It is the authority, the village council who has issued a certificate, Lordship, without the consent of the petitioner, Lordship.
If the village council was present as a party, would your stand be different?
Lordship, It's an individual property,
Just
Lordship.
asking you, just asking you, because out here, you see, the village council is quite powerful. So supposing there were a party here,
Lordship.
would your stand still be the same? We can make them a party also.
Lordship, as and when the matter is taken up, Lordship.
Okay, so you think of that matter,
Yes,
whether
sir.
village council, right? An issue has arisen as to whether the village council should be a party. This is the matter of Thursday.
Lordship. Obliged, Lordship.
Obliged lordship.
But there is one thing on the other hand, his individual rights cannot be trampled also.
My lord, with the consultation of the stakeholder, the village council, being the responsible for the village development activities. So with your consent, I filed my affidavit.
Okay, we'll see.
Yes, please.
Obliged, Lordship.
Yes.
Please, my lord. Lordship, I beg to mention item 8 and 9. If 2 weeks can kindly be granted to file my counter affidavit, my lord.
Okay. 8 and 9, Mr.
And Angami, my lord.
N. Angami, learned counsel for the
State respondents.
state respondents. Is granted how much time?
2 weeks time, my lord.
Granted 2 weeks' time to file affidavit in opposition with regard to the pending bills that have not been paid by the respondent. That have allegedly not been paid by the respondent. This is the matter of 2 weeks.
Lordship, I have a similar prayer for item number 12, your lordship.
Same.
I'm deeply obliged, my lord.
Please, your lordship, maybe please to mention item number 19, 19. Your lordship, here I'm yet to receive instructions, so.
This is a covered matter.
Yes, lordship, however, your lordship, instruction has to come. so-
Instructions.
Your
Yeah,
lordship,
your instructions cannot supersede the judgment passed.
however, your lordship, that opportunity may be granted to me.
What is there to, only thing is that there is some delay maybe. Only thing is that probably back wages will not be given. That's all. You are expecting back wages. Is it?
Lordship, let's see at the end of the.
You cannot write piggyback on the orders of some other person. And delay a case.
All right.
You should have filed it immediately, then it was okay, but you're trying to write piggyback on some other orders after a few years.
Lordship, here the differences is the first 435 who approached this honorable court in writ petition 174/2018, their salary was reduced to 25,000 from 31,350. But the present petitioners, their salary was not reduced.
You were happy with your salary. But once they got the order for regular pay, then you also now want. So you want to write piggyback on their order basically.
Lordship.
But there's no harm in that, madam.
Lordship, however, your lordship, that opportunity.
However,
No, just sometime, your lordship.
for what?
Means
Matter for what? A
at
delay
least-
matter.
At least your lordship, let it be, whatever be the thing, your lordship, it might be covered. At least the government has to give an opportunity to file an affidavit. Your lordship, I'll just
We're
file an
giving you an
affidavit.
opportunity to say something. I mean,
Lordship, and moreover, your lordship,
they are all in the same boat.
yes, your lordship, however, that opportunity will be granted to me, your lordship. This lordship may be gracious.
There's nothing here, madam.
Yes, your lordship.
Huh? I thought I'll dispose it off straight away. There's nothing.
Your lordship, and even
It's
for,
covered by the division bench order,
yes, your lordship.
Yes.
which has been upheld by the Supreme Court.
Yes, Lordship.
What can you do? Your initial appointment was all through the same selection process. Now, unlucky or luckily for those persons, you have reduced their salary for which they came to the court.
Yes, your lordship, but your lordship, that opportunity may be granted to you, so that at least the government will say that, okay, this is covered, so you can, at least that opportunity should be
Day after
granted.
tomorrow?
Oh, your lordship,
Day after tomorrow?
and even for the respondent number 5, I entered the appearance, but I could not able to file Bakalatnama because of the pending
You
strike.
can file memo of appearance. We will allow that.
Lordship, so,
You can ask the government as to whether as to whether this is covered or not. It'll take you just half an hour to read.
Your Lordship, at
Yeah,
least,
but,
2 weeks may be granted, Your Lordship. Maybe gracious, Your Lordship.
Miss Livika, no? Yeah,
Yes,
Miss
Your Lordship.
Livika. No? Let me
Your
dispose
Lordship,
of
I
some
appreciate,
matters.
I appreciate Your Lordship,
No,
so.
no, no. It's not a question of you appreciating. We have to pass orders even if you don't appreciate.
Yeah. That's my humble request, Your Lordship.
Ah, right. Miss Livika is granted
2 weeks, Your Lordship.
2 weeks' time as a last chance to obtain instructions, inasmuch as this case appears to be a covered matter. This is the matter after 2 weeks.
Much obliged, Your Lordship.
Highly obliged, Lordship.
Lordship, I beg to mention item number 11.
11.
11.
Yes.
Lordship, I'm there for 2 weeks' time to file a affidavit in the position.
Okay, Mr.
MTM Song.
Im Song, Learned Counsel for.
Lordship, I would like to raise objection here. Lordship, if we see the records of the proceedings, this particular petition came up on 14th August. In that 14th August, the petitioner's counsel has given a false statement stating that the money is deposited. Now, this matter is not a land dispute. This is compensation. Nagaland Compensation Act 1965, Section 11, subsection 3 says that only the affected landowners will be compensated. Accordingly, several departments went for spot verification. SDO Civil, Ralan, TB's Ralan, they had a spot verification. And the spot number 67A, they were landowners, they were given compensation. However, in spite of that, in spite of fact finding that there is a 0-inch touching the land of their petitioner, they have started claiming 99%. It's a very wonderful. Lordship, this suit is liable be dismissed today itself for the fact that
You're the read petitioner.
no, I'm the respondent, but I'm replying
Oh.
that is why I'm.
We are in the same line.
You see, the problem is we start thinking depending upon where you stand. So, so I was confused. What was happening? Okay. So please stand this side. Now, if the government starts standing this side and starts arguing, I'm going to be doubly confused. Okay, so you're the respondent.
Yes.
John, I'm coming to the fact how proceedings started.
So you mean to say they are disputed questions of fact?
Lordship, they have filed the affidavit, so if 3 weeks' time may be granted to file our reply, Lordship.
Now,
So we'll take it up after some time. We'll
Lordship.
just see after some time. Wait. We'll take it up after some time.
Okay.
Okay.
much-
We can't adjourn all the matters. Some matters have to be heard also.
Lordship, I beg to mention item number 25.
Yes.
Lordship, in this matter, the humble court has allowed the petitioner to go for verification to obtain family pension. But before verification could be done, she expired.
Oh.
So I pray that 2 weeks' time may be allowed to us to file a report along with that certificate.
End of the matter, Mr. Counsel.
Your Honor, she's also claim,
She's unmarried. She's pastic. Correct?
Your Honor,
And then what remains?
this petition has been represented by, the petitioner has been represented
Mr.
by,
Counsel,
legal
the-
guardian.
The person has died.
Your
The
Honor,
person who's making a claim has died. You're the unmarried daughter, correct?
Your Honor.
You're the unmarried daughter. Your father has died, your mother has died. You're the unmarried daughter. You have got any children?
No. Lordship, this petitioner has been represented by the legal guardian. And
Maybe
she's,
legal guardian has got no right. Legal guardian is for the unmarried daughter, not for himself. He cannot pocket the money now and go.
Lordship, the
What are you
question
gonna
is
do?
whether her errors, entitlement errors will be go away along with her demise. She's
Naturally, why
also
not?
claiming for the errors, Lordship.
You debate, nothing remains, Mr. Counsel, nothing
The
remains.
error has been pending since 2009, Lordship. Since 2009.
Mr. Council, first of all, you see, there is a notification issued by the government of Nagaland,
Lordship,
which provides that the DC will make the inquiry and submit a report, correct?
Lordship,
You are making a claim on the basis of the court ruling made in Manipur,
Lordship,
correct?
Lordship,
Then, and the family pension is to be paid by the government of Nagaland.
Lordship.
Then, no, that is not, that's still incomplete. The family, you're not even a family nominee.
Lordship, my humble submission, whether the errors she entitled since 2009 will go
Arrears,
away.
arrears.
Errors, Lordship.
That's why she's not a nominee. Nothing is proved. Nothing remains, Mr. Council.
Lordship, kindly allow us to file a report, Lordship.
Allow you to?
File a report.
You have said everything. What report are you going to say in your affidavit?
Lordship, posthumous verification can also be done, Lordship. I humbly.
And who is
submit,
going to
Lordship.
get the family pension?
That matter can be decided later on, Lordship.
Sorry. Unfortunately, you see, at the end of the matter, I can understand if she had a child or someone was there, but she doesn't. It's the end of the matter. It's finished.
Lordship, her elder sister took care of her since the demise of her mother. So she entitled the family pension and the heirs since 2009, Lordship. So my,
This El Adaha,
the petitioner,
is the one who died.
Lordship.
Huh?
No, the petitioner expired. The petitioner has been
Petitioner-
represented by legal guardian. By legal guardian, represented by legal guardian.
No, sir. El Adaha is the unmarried daughter.
El Adaha is the disabled person, the
Disabled
petitioner.
person. She's dead. End of the matter. What remains? Nothing, Mr. Khan, sorry.
Lordship,
There's no point.
Lordship, my humble submission, the issue is whether her entitlements prior
That is a
to,
different issue.
Lordship. So,
That is a subsequent issue once El Adaha wins. Now, who is going to make a claim for her?
her successor, Lordship.
Who is the successor?
Later on, that can be resolved, Lordship.
Not
Whatever,
possible.
but
It is
whatever
a-
she is entitled since 2009, the question, Lordship, whether her entitlement since 2009 will go away
She's the
along
only
with
daughter,
her
correct?
demise.
She's the only daughter.
No,
Other daughters are there.
other daughters are there, other siblings are there,
Other
her
siblings.
siblings are there,
Other, they are from the same mother and father.
Lordship.
You find a case in their name, this case goes. There's nothing left here. Look, she's the one only who can avail of the family pension. That has not been resolved till now. End of the matter. Mr. Council, sometimes there are hard decisions that have to be accepted.
Lordship, let her legal guardian who represented her in this petition be file a report, Lordship. She was represented by her sister, her legal guardian, in this petition.
She will write, she will say what? What will she say?
Lordship,
What will the legal guardian say?
let her file a report, Lordship.
What will be there in the report?
A report from the competent authority, the deputy commissioner and
You
the,
list it day after tomorrow. You take a decision, right?
Lordship, 2 weeks time, Lordship.
No. You try to convince me within 2 days. Right. Today is Monday, no? Thursday. Mr. Your name is V. Sere,
Lordship,
Learned Counsel for the petitioner submits that the writ petitioner, who is the unmarried ailing daughter, has expired. The issue pertains to whether the petitioner, who is not a nominee in the who is not a nominee in the father's service book, can make a claim for family pension. This is the map. This is the map on third. I'm giving you show me some law. If you can show me some law, then we'll allow you to continue with the case.
Lordship. Obliged, Lordship.
Lordship, kindly allow me to make a mention item 16, Lordship. I'm going to respond number 3. Yet to file my counter, Lordship. If 3 weeks time may be given, Lordship.
Who is for the petitioner?
Yes, Lordship, I'm for the petitioner.
Who is for the respondent number 3?
For respond number 3, Lordship.
So the dispute is between the respondent number 3. You're for the respondent number 3.
Yes, Your Lordship.
Dispute is between you and him
Yes, Your Lordship.
with regard to the construction of the building, correct?
Yes, Lordship.
Whether it encroaches upon your land or not.
No, in fact, the issue here is, Lordship, the respondent number 3 is acting on the permit issued by respondent number 2.
The DC.
No, that is the Dimapur Municipal Council.
Okay.
Yes,
permit.
Lordship.
But gone
On the
beyond
base-
the permit.
Yes, beyond the permit they're constructing. So therefore, I've come before this court challenging the said permit.
Oh, you're challenging the said permit?
Yes, Lordship,
Okay, so the permit,
issued by the Dimapur
the
Municipal Council.
permit pertains to the land
Construction.
of the
Construction,
construction.
Your Lordship.
So, but then is the construction being done within the land of the respondent number 3?
Yes. Now, the permit is giving a guideline wherein there have to be specification, 5 feet, 10 feet on the north. So that has been encroached. That borderline has been exceeded while construction has been carried out
Okay,
So by
but
that-
construction is within the land of the respondent number.
within the land. But as per,
It is not as per the building permit given.
correct, Lordship.
That, so say if there was supposed to be a 5 feet gap, they have made only a 3 feet gap,
Yes, Lordship, that's
for example.
correct.
So this issue will have to be decided by the municipal board.
Yes.
Let them be decided. End of
No,
the matter.
Lordship, in that case, the respondent 2 is absent so far,
Who is respondent number 2?
not present. Otherwise,
We will direct from here. How does it matter? They don't have to be present. We'll direct that you should do it after giving an opportunity of hearing to both, to both the petitioner and the thing. So DC is not required here.
not required, Lordship.
This is not, so that's the simple thing. Why should keep it pending? Because at the end of the day, the issue pertains to the fact, it's a factual dispute, whether there has been 5 feet or 3 feet or whatever. So that is the only thing.
In fact,
Yes,
the
Lordship.
the respondent number 3
Ah,
has also filed a counter complaint saying that that permit was never applied by us.
okay.
And not only that, my neighbor, the petitioner, he has constructed his building up to my wall, no space left.
Okay.
And he is saying now that I should use space.
Anyway, so that, don't let the, because that, everything has to be decided by the municipal board.
Yes.
Because if they are the ones who issued the permit or not, that they will decide. Whether it has, the construction is supposed to be done as per the permit, if it has been issued by them, that they will decide. If it is
Lordship.
not, so let them decide.
Lordship.
But Lordship, I would also like to place the counter complaint which I have filed on record by way of an affidavit. So if a short time may be given to me.
Counter complaint regarding what? You put your counter complaint, you give a
Before
counter
the
complaint to the AMC. You give it to the AMC.
Yes,
You make
I
it,
have already submitted.
that's enough. You submit that, if you want to make a challenge, that can always be part of the record.
Yes, sir.
Okay, we'll record that. Let there be some disposal at least, otherwise I'll be sitting here doing that. I've got to show that I'm doing some work, no? Yeah, for the state, deputy commissioner, nothing for you to say. No? Right. So as per the permit, according to you, the building is to be how far from the boundary?
Lordship, if I may take you to the relevant portion.
Just tell me situation.
Okay,
It's like this. My plot is just about 17 feet. Neighbors on both sides, they have erected their buildings right up to my boundary wall.
They don't want you to.
And they don't want me to construct.
no, Lordship, that
And this
construction is,
permit, I have found out that it is none other than the petitioner who applied in my name.
Oh.
So
okay.
these are the issues.
So those things you take it up there,
before the authority,
because
And so-
we cannot decide
And
that.
so the construction permit says, I will leave 5 feet on either side,
Okay.
which means that leaves me with just 7 feet to construct.
So whether that permit has been issued, has been asked for by you or not, all
Yes.
those, let them decide.
So we'll take it up when the matter is reached.
We can take it up. Give me this item number, which one is that?
16, Lordship.
16. Heard Mr. Akito Zimomi, learned counsel for the petition.
No.
Sorry, heard Mr.
Alibo Uzukum, Lordship.
Alibo
Uzukum. Alibo Uzukum.
Ozukum, learned counsel for the petitioner. Also heard Mr. Akito Zimomi, learned counsel for
Respond number 3.
respond number 3. Mr. LD Sanktam appears for respond number 1. Who is for 2? No one appears for respond number 2. Did they appear earlier?
No, Lordship.
A notice has been served up to
Completed.
them.
By way of testy, Lordship.
Huh?
By way of testy.
That's it.
Already said.
Stop. No one appears for the respond number 2, even though the affidavit of service
Lordship, the complaint.
Filed on 7/10,
Just a minute.
2025.
Affidavit of service dated 7/10/2025,
Lordship, correct.
submitted by the petitioner shows that notice has been served upon the respond number 2 on when? 29/9/2025. As such, notice is deemed to be served upon the respondent. Yes,
The complaint originally,
complaint to whom?
the DMC.
Okay.
After the filing of the writ petition, we came to know that he had applied in our name. This is the
Okay.
complaint we should file. Even the construction permit is different, Your Lordship will know.
Okay, anyway, we'll make this a part of the record. Or you want to give a photocopy?
I'll give a photo later on.
Make a photocopy, now, right? Uh, the petitioner's case is that he is the owner of a building located at GS Road, Dimapur, covering an area of approximately 2736 square feet approximately as per records, and in reality, covering an area of 2362.88 square foot. The petitioner's further case is that the respondent number 3 had obtained a no objection certificate on 18/5/2019 for construction of a multi-story RCC building on the land adjacent to the petitioner's land towards the petitioner's land. Full stop. As per the no objection certificate for construction, the respondent number I've obtained a no objection certificate on so and so from the respondent number 2. Okay. For construction of a multi-story RCC building on a plot of land adjacent to the petitioner's land. Okay. As per the no objection certificate for construction, the respondent number 3 was required to keep a margin of 5 feet distance from his boundary. However, the respondent number 3 has not kept any margin from the boundary while constructing his building. Full stop. Next para. The petitions council submits that though the respondent number 3 has not constructed his building on the land of the petitioner, the respondent number 3 has to keep a distance of 5 feet from the boundary in terms of the no objection certificate granted by the respondent number 2. Correct? Next paragraph. Mr. Akito Zimomi, the learned counsel for the respondent number 3, on the other hand, submits that the land of the respondent number 3 measures 17 feet, about 17 feet. And if he was to keep 5 feet distance from the boundary on either side, his construction would only cover 7 feet across. He also submits that the respondent number 3 has not made any application to the respondent number 2 for grant of a no objection certificate. And the same had been apparently been made by the petitioners. Full stop. He submits that a complaint has been submitted, a complaint dated,
I submit for Xerox copies.
complaint dated so and so in this regard has been submitted to the Dimapur Municipal, to the respondent number 2. Full stop. A copy of the same has also been furnished to the court, and the same is made a part of the record and marked as an exchange. Full stop. Next paragraph. Mr. Angami. L. Sanktam. LT Sanktam. The learn additional AG appearing for the respondent number 1 submits that the respondent number 1 has got no role to play in the present dispute between the respondents between the petitioner and the respondent number 3. And that the dispute can be decided by the respondent number 2.
Yes.
On hearing the counsels for the parties, this court finds that the issue raised by the parties relates to disputed question of fact. The first question of fact is whether the respondent number 3 had applied for a no objection certificate from the respondent number 2, and as to whether the no objection certificate had been issued by the respondent number 2. Secondly, whether the whether there is any bar, there is any requirement of the respondent number 3 from constructing his building.
Lordship, both the petitioner as well as the respondent number 3.
Whatever I said. Any bar for landowners to construct their buildings by keeping a
Lordship,
margin / distance
Lordship, I have a
of
humble prayer.
their buildings from the boundary
Lordship,
wall.
I also have a humble prayer. During pending disposal, the parties may restrain from further construction,
That
at least to that effect. Lordship.
That you'll go to the thing. You'll go to the thing. You'll go to.
Because they are still carrying on the active construction.
Have you stopped?
We have stopped.
Okay.
We're not carrying. In fact, the TMC has stopped us.
Okay, I stopped.
Yes.
Then it's okay. Stopped.
What issue can be taken up?
Yes. Next. The Dimapur Municipal Board? Council shall accordingly take a decision on the issue raised by the parties at the earliest and preferably within a period of
2 months.
Huh?
Within a period of 2 months. 2 months.
within a
That is
period
good.
of
6 weeks.
6
6 weeks.
within a period of 6 weeks from the date of receipt of a copy of this order. The writ petitions accordingly disposed.
Much obliged.
Obliged, Lordship.
May I please, Lordship. Lordship, I beg to mention item number 3.
Three.
Lordship, I'm appearing for the respondent 3. That is the aggrieved party.
Item number 3.
Yes, Lordship. We are waiting for some documents, so Lordship may kindly give us some time to file our affidavit in opposition.
What is this matter about?
Your Lordship, here, the petitioner was a contractor who was executing a contract in that area. And because of the cancellation of the contract, certain dues which he was to make to the persons, the local contractors from that area, certain dues were pending. Now, these subcontractors, they seized my properties worth about 5 crores. And then claiming that I still owe them the money, they have prevailed upon the deputy commissioner to start issuing notices to me. That is how I'm before this honorable court here.
Just give me that item. Now, why haven't you implemented those contractors?
I have, my lord. I have,
You have.
my lord. And they are represented now.
Okay, you're the
Yes,
one.
they are represented.
Okay. Okay, so what do you want?
Lordship, we are waiting for some documents, so can you give us
Okay.
time to file our
Sir,
affidavit?
Mister,
Penyang Lishing, Lordship.
your name?
Penyang Lishing,
Penyang Lushin,
Yes,
land
Lord.
counsel for the respondent number 3.
Lordship.
Are you filing anything? And Mr. LT Sangtam, learned counsel for the and then additionally are granted 3 weeks time to file affidavits.
Interim order to continue, my lord?
Interim order to continue to the next. Yeah, there was one Aliba Sangtam long time back.
Yes.
And he expired, no?
He expired, my lord.
Oh.
He expired a long time ago. Much more.
This is Lordship. Lordship, I beg to mention item number 5, Lordship.
Right.
Yes, Lordship. Yeah, I'm here to receive instructions, so kindly bring 3 weeks time, Lordship.
Where is the service book?
Lordship.
You see, it's very simple. There must be a service book.
Lordship, I'm not in this matter. The leading counsel is in court number 2, Lordship.
Oh. When were you appointed to the service?
Lordship.
When were you appointed to the service? You've got no idea.
Lordship, I was appointed, the petitioner was appointed in 1975, Lordship.
75?
Yes,
Are you
1975.
sure?
Yes, Lordship.
I don't think so. That is the day you were born. That's what the year you were born. That's what you have said. How can you be appointed? You haven't even started walking.
Lordship, my apology, 1996, Lordship.
So you were born when?
1975, Lordship.
1975. According to you.
Lordship.
You studied till what class?
Class, the petitioner studied till class 5, Lordship.
Class 5.
Yes, Lordship.
Where?
Lordship, I have annexed the
You
community
studied in
report.
class 5 and you were appointed as what?
Work charge labor,
Work charge laborer.
Kalasi.
Okay, right. Miss, Madam,
S. Chang, Lordship.
S.
Chang. Chang.
How do you spell?
CHANG.
Chang. Yeah, learned government advocate
Lordship.
is granted
3 weeks, Lordship.
3 weeks time to file affidavit in opposition. The matter pertains to the petitioner claiming that he was born on 21/10/1975, while the government stand is that he was born on 21/3/1964. The petitioner was appointed as a work charge laborer / khalasi on 13/1/1996. And as per the submission made by Mr. What is your name?
Noklay M. Konyak.
Huh?
Noklay Om Konyak.
Conley?
Noklay M. Konyak.
Not here. Nokle N. Ponyak.
Lordship.
appearing on behalf of
Sentiang.
Sentriangan, comma. The petitioner completed his class 6,
Class 5, Lordship.
class 5 in the year
1989, Your Lordship.
1989.
Your Lordship.
In class 5, 1989, you completed class 5. How old would you have been in 1989? From which school? Name of the school, any school?
Yes, Lordship.
What the school's name?
LPS School Senghat Wamsa.
Where is it page? In the
Lordship, yes.
petition,
An extra 50.
NHK 15, NHK 15, huh?
Page 50.
Page 50.
Yes,
Ah,
Lordship.
you write that down. So come on.
An extra
Page
11.
50 of the writ petition from LP school so, okay? Read that. List the matter after 3 weeks.
Lordship, let this be the last chance to file affidavit in opposition.
You have retired.
No, no, Lordship. I was unjustly made to retire, Lordship.
No, you have made,
Yes,
been
yes.
justly made to retire.
Yes, Lordship.
When did you file this writ petition?
Lordship, I filed this on 28/05/2028.
28
28/05/2025.
05.
Yes, May.
Yes, madam, file your affidavit. It's a small matter. Okay, this is the matter, this is the matter of 3 weeks. Last chance is provided to the respondents to file their affidavit. Next,
Obliged, Lordship.
but then with hornbill and all, this is- where will they do? They will not doing.
Yes.
Lordship, I have similar prayer for item 6, Lordship.
Why do you want to take writ? Why don't we dispose of this matter by directing the state government to take a decision on the representation of the petition? That will be faster. Madam,
Yes, Lordship.
what is the matter about?
Non-regularization of the service, Your Honor.
And when did he retire?
30/11/2021, Your Honor.
No, not 21. I don't think so. When, which year?
2021, Your Honor.
21.
Yes, Your
He
Honor.
retired on 21. And you file a case in 25
Yes, Your Honor.
for regularization.
Yes, Lordship. Your Lordship, I was hoping for regularization as per the OM. However, the state respondent has not considered my case, Your Honor.
So
And
the
I was released
so
on
the
30.
representation is there before the government. Correct? Have you filed a representation to the government?
Yes, Your Honor.
Dated?
13 June 2025, Your Honor.
30. Why didn't you file it during your service period? Why after your retirement? Look, one thing we can do, if you're going to continue to wait for the government response on this, it's going to take forever. So what we can do is, we dispose of the writ petition, subject to your approval, with a direction to the respondents to decide the issue by way of a representation, by way of a order, taking order within a specified time period. Otherwise, they will not file affidavit for the next 6 months. The next month is Hornbill. Then you have got Christmas. Then you have got that hangover period, January. So it's going to be a problem. They will not do it.
Lordship, it will short take me with your lordship.
Now, supposing we direct the state government to take a decision. What do you think? Is he a senior here? Is he a senior here?
Yes, Your Honor.
Oh. Yes.
Yes, my lord. My lord, I have praying for regularization in terms of OM, my lord, OM 13/3/2015. So even if this honorable court give the direction to dispose of the representation, but in the state respondent will not consider unless this honorable court give the direction to consider the case of the petitioner in spite of to consider the representation, my lord.
They will not consider.
Yes, my lord.
Just give me that, just give me his case. Let us see the OM. OM is which page?
OM is page 13, my lord.
Hmm?
13, page 13, annexure C.
13, yes.
Yes, ma'am.
It's where, which para?
1 clause 1, my lord. May I read, my lord? All existing workers and casual employees of various departments.
That is all right, but
Yes.
you see, one problem is, you did not make any application for regularization during the time you were in service.
Yes, my lord. My lord.
You have to make an application.
Yes,
prior
that is true, my
to-
lord. Yes.
It means that you've accepted everything.
My lord, the practice here in the state of Nagaland is, in spite of having this OM, many of the employees, workers employees, are considered. The case of the workers employees are considered, my lord. After
retirement.
yes, after 1-2 years also.
Can
But
you
this the
can you give me the examples? Give me examples.
yes, my lord. As of now, I don't have the documents. So, my lord, in that case, I may be allowed to produce some documents. So kindly allow 1 week time, or
No.
this matter may be listed on Thursday, my lord.
We will list it on Thursday.
Yes, ma'am.
Because there are some judgments which are against you.
Yes, ma'am.
I think you know that there are some division bench judgments against you. Supreme Court judgment may be also there. That's why I'm saying that maybe a representation to be decided by the government. Maybe it'll work in your favor. Because I don't know if we can give you a proper decision, not a proper, I mean a decision that you want. We'll give you a proper decision, but may not be what you want. So you'll have to show this court that there has been regularization of these persons after their retirement.
Yes,
Thursday?
yes, ma'am.
Okay, right. The petitioner seeks regularization even though he retired on 30/11/2021.
Yes, ma'am. 30/11/2022.
The petitioner had not made any representation to the authorities prior to his retirement for regularization of his service. And his representation for regularization came only after his retirement. This is the matter of Thursday.
Lordship,
Yes,
item 7 as well, Lordship.
7 also same.
Similar method, madam.
So you see, madam, you have to read some judgments. There are some division bench judgments passed by this court.
Lordship.
So I think recently also it was there. I mean, 2-3 years back, I think there was some judgment. So you just look at them and you also look,
Yes.
okay, because if you can show me instances, even if, but not on the basis of court orders, and or if there are court orders in your favor, well and good. Okay, next.
Ablajo.
7 was the same order. Acha, except the retirement date was 39/22. 39/22 and retirement date was that's what, retirement on 39/22.
Lordship, I like to mention item number 13, Lordship.
Same, what is that?
Here also need to receive instructions, Lordship.
Same. Thursday. Thursday, out here, retired on 1/12/22. Yes, madam, you're there in item 13.
Yes, Lordship.
You retired.
Yes, Lordship. After
And
serving for 24 years.
Did you make any representation for regularization?
After my retirement, yes, Lordship.
So same board, F6 and 7. So we are taking it up on Thursday.
Yes, sir.
You get some judgments. We are going to decide the matter. Tell your senior. Without affidavit. Also. It's a question of law, basically. It's not a question of facts. Okay. So better we just get the law.
Lordship.
There are some
This
judgments.
item 13, my case for regulations was rejected by the Bureau order.
Rejected.
Is
Oh, rejected.
is
Rejected
different.
by
Issue is different. Lordship.
how? Rejected by
Rejected on the ground that my case doesn't come under the OM of 2015 and 2004.
So it's basically the same. We'll see on Thursday. Basically the same. Because the issue is whether you see whether it comes or does not come under the OM. We'll see. You worked for a long time.
Yes, Lordship.
Why didn't you make a representation during the time you were in service?
Lordship, I've submitted my representation. Also
During the
this-
time you were in service?
Yes, although it is not on record, I've made a specific statement in my petition, Lordship. And Lordship knows when there's office memorandum for regularization, it is the duty of the employer to consider regularization.
No,
Although there
provided
is
that
no
you-
representation.
provided you claim your right. Provided you claim your right. If you don't claim your right,
Office memorandum gives us right, Lordship, for regularization.
gives you a right, but you've got to claim it, no? Some people don't claim it. Some people claim it, some people don't claim it. That is why writ petitions are filed, because some people claim their rights, some people say their rights are violated. Some people keep quiet about it. So Thursday.
Lordship.
Lordship, item 14 as
Oh
well.
my God. Item 14 also.
14.
Madam, this is salary. You pay the salary, what is there?
Lordship, I'm appearing on behalf of my colleague, Lordship.
Who is your colleague?
Ichano.
What's in you?
Lordship.
You're for the petitioner.
Lordship.
Your name is Supamati.
My lord.
So your case is what? That you are not given your salary.
Lordship, I was appointed on compassionate ground, Your Lordship, on compassionate basis. And then I was appointed on 24/5/2023. And then from the
4/5/2023.
yes, Lordship. And then from May to October 2024, my salary has not been paid.
Why?
Lordship, for that reason, I'm before this court, Lordship.
Let me know that. Your appointment order is there, and you have
Lordship.
been working.
Lordship,
Madam, why should we keep all these matters here? Right, I think we'll dispose it of, madam. There's no point. Okay, right, heard?
This matter can be listed tomorrow, Lordship. The living counsel is not here to give.
Where is she?
She couldn't be here to give, Lordship. She has some personal difficulties, Lordship, so.
Okay, right. Adjournment prayer has been made on behalf of the counsel for the respondent. By Miss, your name?
S. Chang.
S. Chang.
Lordship.
She submits that the matter may be listed tomorrow. List the matter tomorrow. Next para, you write. The matter pertains to non-payment of the petitioner's salary from 24/5/23 to November 2024. In terms of the office order dated 24/5/2023, issued by the Engineer-in-Chief, NPWD, Nagaland, Kohima, appointing the petitioner as Ferro Printer, FERRO Printer, on compassionate ground. List the matter tomorrow.
Obliged, Lordship.
Tell her that we're disposing it of tomorrow.
No.
Okay, and if she wants any instructions, let her get it.
Lordship, item 18 as well, Lordship. On behalf of my colleague.
Item 18.
18, Lordship.
Steps upon the private respondent are yet to be completed, my lord. If I may be permitted to take steps by registered by dusty service, my lord. Registered 80 we have attempted on several occasions, lordship.
Yeah, Mr. Sentianger.
Yes, my lord.
Now you tell me, you are asking for appointment on land ownership basis.
Yes, lordship.
Land was donated when?
I'll have to. The facts, lordship, perhaps I'll need to go through the petition.
No, we'll go through together. Give me the file.
I'm afraid, my lord, there is no mention of when the land was donated, except
Now,
for the fact that
now,
the
who is the
petitioner-
owner of the land?
the petitioner's husband.
Petitioner's husband, the owner
Yes,
of
my
the
lord.
land. Petitioner's husband, was he recommended for appointment? For the land in question?
Petitioner's husband.
Petitioner's husband?
No,
No.
it is the petitioner who has been recommended for appointment, lordship. Because the land on which the medical center is established at Chakpang village, lordship, under Mon district.
You see, the land belongs to the petitioner's husband.
Yes, lordship.
Where is the petitioner's husband's letter that this land should be, that his wife should be appointed?
No. It is only the petitioner who has made such application before the department, lordship, before
No,
the
but
principal director.
she's not the landowner.
Yes, she is not the landowner,
Then
lordship. But
where's the
her
question?
husband is the landowner, lordship.
So where is the letter from your husband that you should be appointed? In place of the husband?
I'll have to check the petition again, lordship.
Huh?
I'll have to landowner certificate, lordship. Lordship, annexure 2, land ownership certificate.
Yes.
This is a registered document.
What
Lordship.
date is this? 5th April 23.
Yes, lordship.
Now, when was this land given?
That we have that mentioned, lordship. In the
You
petition.
please give us the details. You cannot, you have to come with clean hands, Mr. Counsel.
No, there is no question of us approaching with unclean hands, lordship. Yeah.
Maybe, but then you've
Yes.
got to tell us.
The land ownership certificate, lordship. And the,
You see, when was the land given to the government? He has not,
no,
that
no,
question.
that I have that, we have
No,
that.
that is very
stated in the
important.
petition,
Whether, how old is your husband?
The petitioner is age 31. But
That much I know.
Yes, lordship.
That much I know.
Oh, I'm not aware whether
No,
how old the
this-
husband is.
This matter is without any specifics. You have not given specific. You have to give specifics. When was, and that land is being used for what? Medical subcenter at
Yes, lordship,
Japang
at
village.
Chapang village.
So when was this land and when was the subcenter made?
Lordship, in that case, lordship, when the land was donated, that particular fact we may be allowed to place before this honorable court by filing an affidavit.
Letter from the petitioner, from the landowner, that his wife should be appointed.
Annexure 2, lordship, the certificate, lordship. In the last line, lordship, whereas Srimati A. Tanyu Konyak, wife of Sri E. Yong Konyak, being a bona fide landowner, is hereby recommended for appointment as a landowner, a deserving local candidate. This is signed by the SCO civil of the area, lordship, the chairman of the village, the petitioner's husband, and the village Kambura, lordship, as well as the chief medical officer of Mon district. She is the CMO is the head of the department at the district level. Page 32, my lord. Regarding lordship, when the land was donated, I may kindly be allowed to file an additional affidavit to that effect, lordship. We'll file it within the course of the week.
So son has been appointed also.
No, Lordship. The petitioner is age 31 only.
Come to page 45. You know, but who is this? Who is this person?
Dukun na sila. Yung dala pa dyan.
You see, page 45, Shri
Lord.
Alim Konya.
Yes, this is the impugned.
Father's
approval-
name is Young.
Yes, my lord.
Same, your husband.
No, Lordship. They share the same name, Lordship, the command name, but the person is different, Lordship.
You come to the next page, 46.
Yes, Lordship.
Miss A. Tanu
Yes, Lord.
Konyak is petitioner,
Yes.
wife of Young again.
Yes, Lordship.
Same.
Yes. Nine. They are different Eons, Lordship. Same name, Lordship. Same village, same name, but different persons, Lordship. We are aggrieved by this page 45, Lordship. There is also a clarification report at page 60, my lord, annexure 19.
Where is Shri Young Konyak, husband? Inherited Angship.
Yes, Lordship.
This land has been given long time back. Page 61. Okay, right. Miss
S. Chang.
S. Chang, learned government advocate, is granted
2 weeks left.
4 weeks time to file affidavit in opposition. Mr. Senti Younger, learned counsel for the petition, shall file an additional affidavit stating as to when the land on which the Jakpang sub-center had been built, had been donated for the said, for the same. The council shall also clarify page 61 of the writ petition, which implies that the land for the sub-center had apparently been given a long way back. This is the matter after 4 weeks.
Lordship, I may be allowed to take steps upon the private respondent by way of trustee service, Lordship. So far, we have been trying by registered ID, but it is yet to be affected, Lordship. We may continue to try with the usual course also, Lordship, but additionally, we may be allowed to take steps by way of trustee service, Lordship.
There is nothing else which has been stated, yes, sir. Notice issued upon the.
Respondent number 7 is the private respondent here, Lordship.
Petitioner is also allowed to serve notice upon the respondent number 7 through trustee service. This is the matter of the 4 weeks.
I am deeply obliged, my lord. Lordship, there is an interim.
What is the interim?
Stay of the approval, page number 45, Lordship.
Approval of respondent number 7,
Yes, respondent number 7's appointment, Lordship.
interim order to continue till the next date.
I am deeply obliged, ma'am.
My lord, I beg to mention item 10.
10.
Yes, ma'am. This pertains to arrests under NTPS case. Ma'am. And at the moment, investigation is in progress, so I may be allowed to file my affidavit within a period of 3 weeks. Time. Because the petitioner is on bail.
Yeah, Mr.
Eliran,
Yes, so what do you got to say?
I have no objection to the time slot.
No objection. What is your case here?
Basically, I'm seeking a stay on the disciplinary proceeding. Under
Why?
the two parallel proceedings against the petitioner. One is criminal.
Is there any bar?
No, there's no bar as such, but there's an exception to the effect that if both the proceedings are based on identical set of facts and circumstances, it is desirable that the disciplinary proceeding be stayed. So only on that ground,
Desirable means that is discretionary
yes, it's discretionary, of course.
upon the court.
Yes, your lordship.
Then
I'm on that only on the exception to the, just to show that the allegation is that the petitioner has been arrested on the
selling drugs.
for possession and supplying of illicit drugs. Now both the grounds for the proceedings are same. Only on
Where
the,
is your citation?
I have on the earlier occasion I have produced one citation. It may be in the case file. This is 1999 3 SCC 679.
Yes.
Yes, I'm relying on paragraphs 13, 17, and 34. 13 basically it states the law. Should I read out?
Yes.
Paragraph 13. As we shall presently see, there is a consensus of judicial opinion amongst the high courts whose decisions we do not intend to refer to in this case, and the various pronouncements of this court which shall be copiously referred to on the basic principle that proceedings in a criminal case and the departmental proceedings can proceed simultaneously with a little exception. As we understand, the basis for this proposition is that proceedings in a criminal case and the departmental proceedings operate in distinct and different jurisdictional areas. Whereas, in the departmental proceedings where a charge relating to misconduct is being investigated, the factors operating in the mind of the disciplinary authority may be many, such as enforcement of discipline or to investigate the level of integrity of the delinquent or the other staff. The standard of proof required in those proceedings is also different than those required in a criminal case. While in the departmental proceedings, the standard of proof is one of preponderance of the probabilities. In a criminal case, the charge has to be proved by the prosecution beyond reasonable doubt. The little exception where maybe where the departmental proceedings and the criminal case are based on the same set of facts and the evidence in both the proceedings is common without there being a variance. Now, paragraph 17.
Yes,
Yes, 17.
yes. Please read.
Yes, 17. These decisions, I'll just read out the first paragraph. These decisions indicate that though it would not be wrong in conducting two parallel proceedings, one by way of disciplinary action and the other in the criminal court, still it would be desirable to state the domestic inquiry if the incident giving rise to a charge framed against the employee in a domestic inquiry is being tried in a criminal court. Now, if your lordship may come to the next page,
Yes,
page 689, second line.
yes.
The court further observed as under. In the instant case, the criminal action and the disciplinary proceedings are grounded upon the same set of facts. We are of the view that the disciplinary proceedings should have been stayed and the High Court was not right in interfering with the trial court's order of injunction, which has been affirmed in appeal. And in regard to the facts as emanating in this case, at paragraph 34,
Yes,
the paragraph 34.
yes.
There is yet another reason for discarding the whole of the case of the respondents. As pointed out earlier, the criminal case, as also the departmental proceedings, were based on identical set of facts, namely the raid conducted at the appellant's residence and recovery of incriminating articles therefrom. The findings recorded by the inquiry officer, a copy of which has been placed before us, indicate that the charges framed against the appellant were sought to be proved by police officers and punch witnesses.
Mr. Counsel,
Yes.
if the trial takes a long time, and usually it does,
Hmm.
in a criminal proceeding, takes a long time.
In that case, the
Not as a
the
Supreme Court
concerned
say-
authority also can come before this court.
Huh?
In that case, the concerned authority also can come before this court and seek for a continuation of the proceeding, disciplinary proceeding, on the ground that the trial is taking time. But as far as this is concerned, my only submission is that the disciplinary proceeding. Now, if your lordship may come to page 24.
Yes,
First page 21. Page 21, it states the ground of arrest, the reason for arrest, for possession, supplying of illicit drugs to Mrs. Mary and Mrs. No, these are the two co-accused. And at page 24, this is the statement of charge frame against the petitioner. Article 1. That the said so-and-so posted to RH Longleng was charged for possessing / supplying of illicit drugs to the co-accused. And the petitioner was arrested only on the basis of the statements made by this co-accused. And if your lordship will look at the witnesses in these disciplinary proceedings, at page 25, it's the IO and the two arrest witnesses. Now, there was no seizure. So possession is ruled out. It's a question of supplying, whether he has supplied. Now, this, as far as the statements of the co-accused are concerned, it's, of course, even though Evidence Act is not applicable in the disciplinary proceeding, but it's covered by section 30. And based on that, the petitioner was released on bail. So I'm submitting that prejudice will be caused to the petitioner if the disciplinary proceeding is to be continued.
so what is the state of the trial?
Charge sheet is yet to be filed.
This time may be granted. 5 minutes.
Okay, Mr. If I'm come, learned additional regime, and 3 weeks time to file affidavit. This is the matter.
Lordship, I will to mention item number 17.
You're not going to finish the entire list by mentioning it.
Lordship, here I'm for respondent number 2 and 3,
Yeah.
and I have instruction to prepare for respondent number 2 and 3.
In item,
17, Your Lordship. And this morning only I filed my backup number.
or 2 and 3.
Yes, Lordship.
Okay.
So kindly grant me 2 weeks time to file my verification position.
I have no objections, Lordship.
Mr.
Mr. Kajish, Lordship.
Learned counsel for the respondent number 2 and 3 is granted. How much time?
2 weeks time, Lordship.
Sure,
Yes, Lordship.
no more adjournment. No, don't ask 2 weeks if you're going to ask for another 2 weeks later on.
Lordship, 2 weeks.
Are you sure?
Yes,
For 2 weeks time, wait for 2 weeks time to file an affidavit in opposition. This is a matter after 2 weeks.
Lordship, there's an interim. If you
Interim
can
order
kindly
to
continue.
continue to the.
Deeply obliged, Lordship.
May I please, your lordship? Lordship, I beg to mention item number 4.
Oh,
Yes, your lordship. Lordship, here the leading counsel, Sir Imti Longjam, is undergoing medical treatment. Lordship, we have also applied for leave of absence. Kindly grant us 4 weeks time to file.
madam, this is the case.
Lordship, here we are aggrieved by the order dated 15 April 2025, passed by the Deputy Commissioner Nagalin,
What did the deputy commissioner say?
to dismantle the gate to the approach road, which is at the approach road. So
So
the,
whether the road belongs to you
yes, your lordship,
or not
it's a
is the
private
issue.
property. Yes,
Correct?
yes, your lordship.
So who is to decide that? It's a disputed question of fact. Correct, madam. Supposing I say, supposing supposing we say that the road down there belongs to the High Court. Who will decide that? The authority concerned.
Yes.
High Court is not the authority for them. Now, out here, the decision has been made by the DC. Correct?
Yes, your lordship.
Against you. As per the 1886 regulation. Now, is there any appeal provision in the 1886 regulations? No idea.
Yeah, they would have to approach, here in Assam, there is a revenue board, the appeal, but here in Nagaland, we don't have. So the only avenue available for the aggrieved will be, assail that on appeal by a competent civil court. Or approach the civil court.
Otherwise, now, what is wrong with the DC order? That is the issue. Let us see the DC order, item 4.
Page 26.
Page 26.
Lordship.
The Atopi Sumi and Atopu Chofi, they are same.
Chopi is the petitioner here, and Shri Pomipen Kikon.
No, but then in the cost title here, it is written as El Atopu Sumi.
There's same.
Same.
Same one.
Chopi and Sumi will be same.
Chopi is a title and Sumi is a tribe. They usually use.
Okay. Okay, and L is not here in this order. Okay. Then.
And we
So
are.
you are
I'm responding number 4 and 5 to that.
you are this Paume Pem Kikon.
Lordship.
Madam, you have asked for filing affidavit in reply twice already.
Yes, Lordship. Lordship, the leading counsel is under medical treatment.
Under medical
Yes,
treatment.
Lordship. We have also applied for a leave of absence.
Viranjan? Medical, taken the med, huh?
Also informed by the legal counsel.
Right, the petitioner is granted 3 weeks' time to file affidavit in reply. This is a matter of 3 weeks.
Much obliged, Your
Highly
Lordship.
obliged.
No more.
For motion, item number 1.
It is lordship. This is
Yes,
compassionate appointment, lordship. The petitioner's father, he expired in the year 2014, lordship.
2014.
Yes, lord. And the petitioner's mother has applied for appointment on compassionate ground. The same was not considered.
This is item 1.
First item, lordship.
Yes.
Now in the year 2018, she has become overage to consider for appointment. And that is how the present petitioner, the son, he applied for the appointment, lordship. Lordship, in the state of Nagaland, there's a policy which was formulated in the year 2015. It says that the government employees who die in harness, the spouse, son or daughter can be considered. And in the year 2015, it has revised the existing scheme.
Mr. Counsel, when your father died in 2014, how
Look.
old were you?
I have to check the age.
You were a minor.
Yes, lordship, I was a minor.
So you had no right. On the date your father died, you had no right. Have you seen the latest judgment of the Supreme Court, Deborah Brata Tiwari?
Lordship.
Long delay, whether it may be due to the government or due to the applicant, does not give you any right. You've got no case.
Lordship, if your lordship may kindly appreciate the also one the precedent the judgment which was passed in the month of February this year, lordship. It has observed in paragraph 23 that if I was diligent,
If you're diligent.
if I was diligent, lordship.
You are a minor, you've got no right at the
Lordship,
time.
I
it
agree.
died.
I was only 12 years at that point of time, lordship. I agree, lordship. But lordship, the sole purpose of this
Supreme Court has
scheme.
said that there cannot be a reservation of a vacancy for compassionate appointment till you become a major.
Even otherwise, lordship, there were 158 appointments made, lordship. There were existing vacancies. My mother's application was kept in cold storage, lordship, for the last 12 years,
This
lordship.
is your mother's case. Let your mother come.
She has become overage, lordship, which is why I have filed in another
Then you should
application,
have-
lordship.
Then you should have said that there should be a condonation of your mother's age. Because it was due to the fault of the government in not considering her case at the relevant point of time. The right, first of all, compassionate appointment is not a vested right.
I agree, lordship. I agree, lordship.
Number 2, your mother had applied.
Lordship.
Now, your mother, if she had not been considered during the relevant time, she should have filed a writ petition. She did not do that. And now also she has not filed. You have filed. You cannot take over from your mother. Where is the law? There's nothing like that. In fact, the law says that if you have survived, you see, the object of compassionate appointment is to ensure that the family is given relief, immediate relief.
Lordship, I agree, lordship.
The objective is that. Now, when more than 10 years have passed, it is deemed, it is implied that you have been able to survive.
Lordship, in the case of Canara Bank, lordship, the recent judgment of the Honorable Apex Court, lordship, it has discussed about even all those aspects, lordship. Yes.
I'm sorry.
And lordship has also in that particular judgment, The dependence, Lordship, they were also discussed. The issue of
This is
dependence,
the
Lordship.
law. Deborah Brother say what is the law? It cannot be allowed.
In that case, Lordship, if I may be given a liberty so that the petitioner's mother can approach Lordship.
That I cannot give in this. This is the son's
Because
petition.
there's a relaxation clause
You
even
file,
in
you
the scheme,
see,
Lordship.
there is no bar for your mother to file.
Lordship.
There is no bar
If
for
that-
your mother to file.
Lordship, if that is the observation.
But then there also now 10 years have elapsed, even for your mother. That is the problem. Your mother should have come prior to just completing that overage, should have come. Or after overage also she can still come. But you should come within a reasonable period of time.
Lordship.
You've got no case, right?
Lordship, Lordship, yes. I'll
Of
take
course it
appropriate
is.
steps, Lordship.
Huh?
I'll take appropriate steps, Lordship.
I heard Mr. Muajami, learned counsel for the petition, who submits that the petitioner's application for compassionate appointment submitted on when? When did you submit your application?
Lordship, it was only this year, Lordship.
Now, when? That's what?
23rd April 2025, Lordship.
23 April 2025.
Yes, Lordship.
Not having been decided by the respondent authorities, the petitioners filed the presented petition. Next. The Miss, your name?
Yes, Chamber.
S. Chung, learned counsel for the state government. On the other hand, submits that there being undue delay on the part of the petitioner in applying for compassionate appointment. And as the petitioner was a minor during the time the petitioner's father died, no right, the application for compassionate appointment should be rejected. Full stop. I've heard the counsel for the parties. The facts of the case shows that the petitioner's father died in harness on 16/11/2014, Lordship. Full stop. The petitioner's mother thereafter submitted an application for compassionate appointment. The same not having been considered, as claimed by the petition, the petitioner who was the son of the deceased, filed the application for compassionate appointment on 23/4/2025. Next part. One thing that is apparent is that more than 11 years have elapsed from the date of death of the petitioner's father. And and it shows that the petitioner and his mother have survived the immediate loss of their father. When the objective of compassionate appointment is to mitigate the suffering, the immediate suffering caused to the family of the breadwinner, the delay in filing an application for condonation of delay What do I say? of the breadwinner, of the family's breadwinner. The delay in filing the application for compensation delay. Shows that the sense of immediacy for compassion appointment has been lost.
Lordship, I may be allowed to withdraw it and take great stays by the mother, Lordship.
Okay, okay. Okay. I'll finish the thing.
Lordship, Lordship.
Huh?
Lordship.
Is lost. This has been succinctly laid down by the Supreme Court in the case of State of West Bengal versus Debra Brata Tiwari and others. 2025 5 SCC 712. At this stage, the learned counsel for the petitioner submits that he would like to withdraw the writ petition.
Lordship.
The prayer of the writ petition is allowed. Writ petition dismissed as withdrawn.
Obliged, Lordship.
From the supplementary cost list for motion, item number 28.
May I please, Your Lordship, Lordship, my sincere apology. I forgot to mention in item 4 that there is an interim.
Which
So-
one? Which item?
In
Number?
item 4.
Item for interim order to continue to the next.
Lordship.
Yeah, please, Lordship.
Item
Supplementary.
or supplementary? Yes,
That's,
madam.
Yes, may I please, Lordship, as per this honorable court on 14/11/2025 has given the direction to the state respondent to bring the update. So and I am informed that they have issued a revised shortlisted candidates for interview. So basing on that,
Yes, Your Lordship, I received an instruction that the petitioner is in the successful list. However, due to inadvertence, it was published. So it has been rectified accordingly. So the petitioner has become infectious.
Madam, we have become slightly thin, I think, no? From before.
I don't know.
That plumpiness has gone a little bit. I haven't seen you for a long time.
Yes, Your Lordship, it's been quite familiar.
Quite some. Last time I came, of course, I came once for a short time in December in 2023. Otherwise, the last time I came to Nagaland was
Quite
before
long.
COVID. Before COVID.
Yes, Your Lordship, quite long.
Anyway, right. Miss
Mika H. Your Lordship.
Mika
H.
H.A.
Lordship.
A.
Yes, Lordship.
Learned counsel for the petition. And Miss Livika Leonard J.
Yes, Your Lordship.
is present. The petitioner's case is that the petitioner the petitioner's name failed to find place in the list of successful candidates for filling up the post of mechanic helper / MTS pursuant to the advertisement notice dated 26/8/2025 as well as the re-advertisement dated, it'll be re-advertisement only, no? Or both? And re-advertisement dated 12/9/2025. Next paragraph. Ms. Livika, the learned GA submits that there was apparently a mistake committed by the respondent, and in fact, the petitioner is amongst the list of successful candidates who is to be interviewed.
Yes, Your Lordship.
Who is to be interviewed? Who is to be interviewed for the said vacant post of mechanical helper / MTS. In view of the submissions, in view of the submission made by Ms. Livika, the present writ petition has become infructuous. The writ petition is closed as in.
Lordship.
For admission, item number 2.
Item 2.
Your Lordship, I need some time to file a reply for your Lordship.
You are not filing a reply.
We have to file a reply.
Why?
I need some time, Your Lordship.
What documents do you want?
Your Lordship.
Is this an appealable order?
No.
Huh? Not a appealable order.
That's a 227.
It may be 227, but just because it's 227 does not mean that so the order 43 will not apply.
No, Your Lordship.
Huh?
No, Your
Your application is under what? Section 11?
No, Your Lordship, it's under Order 11.
Under Order 11, Rule 14.
12 and 14, Your Lordship. And Section 30. Your Lordship, give me some time, I'll file my reply, but then can fix for hearing. Your Lordship.
Mr. Praveer Chowdhury, learned counsel for the petitioner, is granted how much time?
3 weeks after 3, let it come in the
Granted
January.
3 weeks time to file affidavit in reply as the last chance. List the matter on, give a date.
After vacation, Your Lordship.
Give a date.
Vacation, Your Lordship. Let me see.
After vacation, you mean after Christmas?
Christmas, Your Lordship.
Then you look at May. May of 2025 is the January of 2026.
Oh, अच्छा.
May of 2024, 2025 is January. May of 2025 is January of 2026. 20. 1/2026.
Interim order to continue, Your Lordship.
Interim order to continue till the next date. Who's for the other side? No one is there.
Other side, he has some difficulty already. Rang me up. He has to go out of station.
Okay.
He rang me up.
Just right, no one appears for the respondents.
He gave me a call that he was some.
Doesn't matter. I've given you time.
Okay, deeply.
For admission, item number 11.
Yes. Just a minute, just a minute. Yes. You're for the petitioner.
Lordship, I'm appearing for the leading, on behalf of the leading counsel for the petitioner, Lordship, PP Paul, who is out of station for some few days, Lordship. The private respondent have filed their affidavit in opposition, Lordship. So if 3 weeks time may be granted, Lordship, to file our reply to the affidavit in opposition.
You're for appearing for whom? The council?
Lordship, I'm appealing for respondent number 678.
Who are they? Who is 678?
Agreed parties.
Who are they? Who are the agreed passive?
The villagers and the chairman and the GPs.
Okay, okay. So you're the one who passed the orders.
Lordship, order was passed in a very surreptitious manner where I am the affected party. Spot verification report is there. We can see.
No. Wait. Just a minute. 678. Who's 678?
Lordship,
Their village council, Moithong. Who is Moithong?
I'm representing him. I'm the respondent number 678. Respondent number 6 is the village, 7 is myself, 3rd is the GP. Lordship,
So just a minute. His case is that he is the owner of land.
I am the owner. They gave for an appeal. It is supposed to be an appeal, but they gave us a writ petitioner. This is supposed to be second appeal. So I will clarify all that when the time is often.
No. How can it cannot be? It can be a no. This cannot be a second appeal. You have not come through the civil court.
This is why Lordship asked for rule. First court, they appeared in commercial court, as per customary court. Then they went up to district customary court. So thereafter, instead of going for this civil court, they have come to writ petition, the High Court.
Give me that what I could do.
Instead of going to the civil court, they have come to the High Court.
So it's not a district council also.
This is, Lordship, this is purely customary court, which is given authority under 371A.
No. So the issue is with regard to who is the owner of land, is it?
No, we are not debating upon the owner of land. I am the owner of land. It is very clear to say there. Compensation.
No, Mr. Counsel. If it was very clear, he will not be here.
No, Lordship, let me stretch the whole kind of the case. And it will be clearer to the Lordship. If I am given the permission to give.
Yes.
Then.
No, but there is one problem.
No, Lordship.
Can we dispose of the matter in the absence of his senior?
No, Lordship, I'm coming to that.
State also it.
Yes.
I'm coming to all that, Lordship.
No. I agree you'll come, but I am afraid that it might be futile for the simple reason that the petitioner's counsel senior is not here. His senior. His senior advocate is not here.
I will reply to that, Sir Lordship. How?
You reply. So what you reply to that first?
Lordship.
Why is the petitioner's senior counsel not required?
Lordship, the petitioner senior counsel station report. Now, as per order dated 14/8/25, that is the order of this honorable court. The senior didn't come, but his junior came. His junior came and submitted that at para 3. He said that the learned counsel for the petitioner has submitted that the petitioner has a plot of land in the Shayan village under Gauhati district, through which the IGGL tax pipeline have been laid. He submits that the entire portion of the land belongs to the petitioner has been affected and compensation in regard to has already been deposited before the
Deputy Commissioner.
That is false, Lordship. Till now, it has not been deposited. That is false submission. Number one, spot verification has already been conducted by none other than the exclusive, the Tobashis, all the parties, and the all the departments. They found that no the inch of land touches the land of the petition, present petition.
Okay, okay.
So these are the fact of case. Now, Lordship,
So, but what about this portion? What about the para 4? Is this para 4? Please, para 4.
the land comes to the petition for the service, the petition not getting the compensation. False, because their land has not been touched. It will be seen.
Please carry on reading. Okay, false.
Okay,
That part is false.
For the use of the land for laying the IGGL tax pipe, company has filed a complaint before the exclusive land, and accordingly by order dated 10 December 24, the land customary court have passed a judgment in the land observing 60% compensation to their village land. As 60% of the company received from the company against the use of the land of the petitioner will go to Lishaya, 40% to him, to the present petitioner. But his complaint is false. Why? Because
No,
they
but
convict this man. They convict this man because he was present in the spot verification.
no, Mr. Counsel, there is one issue. If his land was not touched,
Lordship,
why should he be given 40%?
appeasement.
Huh?
Appeasement. I will come back to that also.
Appeasement? Why appeasement?
It is very clearly stated at page 83 of their petition. It's very clearly stated here. He has given so many adverse kind of remark against it.
Page 83.
Page 83 of the petition, this petition.
Yes.
May I read, Lordship?
Hmm?
Shall I read?
How long will you take? That's not what I'm worried about.
This is the judgment of the district Probation Court.
Okay, this is the petitioner.
Petitioners, they have come appeal against this. But that's why I'm saying they should have gone to appeal against this if they are agreed with the civil court. But straight away they jump here.
Show me the law where the order passed by this court, by this district customary court, is appealable to the civil court. Where is that?
I will. If a proper hearing is taken, I'm ready to submit my preparation, but I will see only the operation part. It may further be stated that a writ petition cannot be filed instead of second appeal because the legal system requires to exhaust the statutory remedy of first appeal.
You see, Mr. Counsel, the law is very clear that a court order cannot be challenged under Article 226. That is very clear. What I'm asking you is, where is the provision which provides that an order passed by a customary court is appealable before the district court, civil court? Where is that?
Let me complete the option. The court generally declines to entertain a writ petition when an affidavit alternate remedies such a second appeal is available. The filing of writ petition before the honorable court by the petitioner prior to exhausting all of the alternative available may be objected for the fact that unless any fundamental rights has been violated or any order that is wholly without jurisdiction, the normal procedure is to use the available statutory appeal route first.
That is what I'm asking you. What is the statutory route that is required for him to follow?
Here, Lordship, the Appellate Court says that anything which is to be appealed has to go through this judicial, first class judicial magistrate.
Show me that.
But that order was, I didn't bring the order, it is 2013 GLB 4. It is still there. When a very long distance region has been affected with first class magistrate, first class judicial magistrate.
Justice Goel's order, is it? Justice A.K. Goel's order.
That is the order for the whole notice. But I do not think it is reported in GLB Part 4, 2013
I don't have a photographic memory like yours, Mr. Council.
I find
Unless
that-
you show it to me black and white, very difficult for me to know.
Since it was not very relevant for I got this, then anyway, this can be extended up to tomorrow is not there, but watch it, it go to the level we to bring the ruling. Otherwise, the ruling says so. Otherwise, we can go for now.
Yeah, 2014,
2013.
13.
As I did this part 4, I did Registrar General Gauhati High Court versus Union of India and others.
I think Justice A.K. Goel's judgment, is it?
You know what?
Justice A.K. Goel's
I
judgment.
just
Division bench judgment. Is it?
Lordship, I have not been practicing the court for a long time, sir. I cannot just immediately. No, please, sir. I will. But I still can remember it is 2030 because I referred this in the similar case in PC court. PC court Mokha. I told him that it cannot be here now. You have to go to the civil judge because it is very clearly written in the JLD 2030.
So let us take it out. 2013.
2013 part 4, I think. Registrar General Property High
Page
Court.
page number.
Not remember. I have to check that. Meanwhile, Lordship, I should take care of that. Let me complete the submission.
Mr. Council, there's no point. For the simple reason that if you're not going to be able to complete your submission, there's no point listening to you and make a submission which is only half of your submission.
Lordship, but the shortcomings in this petition, that is one problem. And
Look, you just show me that judgment.
No, that's only. So,
After some time, we'll take it after some time.
otherwise we can take it after lunch.
Okay, after lunch also, no problem.
Yes, I think that is the, we are not going to submit this honorable report.
Huh?
We are not going to submit before the honorable court the satisfied report. I will satisfy report.
I hope so. That's why I hope so. That's why we're giving you time.
Lordship. So let us make it after lunch report.
Okay. After lunch,
Lordship, without my senior.
let us hear him out.
I will explain everything, why the senior has not come, who will involve, how the things are having.
No. You cannot say everything and anything. You'll have to limit yourself to maybe 5-10 minutes. Get to the point. Show me the law.
I'll do that.
That's enough.
I'll do that.
For hearing, item numbers 20 to 22.
My pleasure, Lordship. Lordship, here the matter pertains to landowner appointment.
Yes.
Lordship,
This is regarding the same land in all the three writ petitions.
Lordship.
Yes, your lordship, and if my lord may kindly allow me, land compensation was paid, 2 appointments on a basis of land ownership has been given. 3% from every contract work has already been given to the petitioners. So if
3% have been given?
3% of the contractual works.
Okay, have been given to these landowners.
The landowners. So if we go by a 2008 notification, 2018 notification, my lord. Respectfully, my lord, it appears to be a destructive and disruptive litigation, my lord.
No, nothing. No destructive, no disruptive.
Because, my lord,
He's just claiming his right. Let us see if he has it or not.
My lord, your lordship.
Yes, so you're the owner of land, or your family was.
Lordship,
You cannot be,
my
so,
clan.
you are only 23 years old.
Lordship,
Land was given in 1978.
land was, yes, Lordship, it was given on 1978 and then as my senior is submitted, Lordship, a sale deed agreement was executed on 23/6/1978. Lordship, page 15, type copy annexure 1. This is the agreement.
In this 215,
Lordship,
page 15.
15. 14 is the original copy, but it's not clear, Lordship. So my type copy is 15.
Agreement dated? No date.
Agreement is not entered here, Lordship, but it was, I was informed that it was done on 23/6/1978, Lordship.
A plot of land measuring Sri Sayam Suba head of land located at so was allotted payment of land compensation on payment of land compensation.
Lordship,
So compensation has been given
conversation given, Lordship.
with the following appointment of
Lordship, it's grade 4, Lordship.
appointment of grade 4 should be offered to landowner. Contract work should be given order to land.
Lordship, and then I'm claiming on the basis of these terms and conditions. One
Landowner
is the
Sayang
Sayang Suba, he is the head of the Patitsar clan, Lordship.
is the head of the clan.
Lordship.
Exactly.
And then after the agreement was been executed, Lordship, as per the not till date, none of the landowners has been given appointment till date, Lordship. And then on
This Khensa village
Lordship,
consists of how many houses?
Lordship,
How many houses in Khensa village?
Lordship, approximately around 1,200, Lordship.
1,200.
Lordship,
1,000. How many families? 1,200 families. What is the population of Khensa village?
around 3,000, Lordship.
3,000. And in 1978, what would have been the population?
Lordship, I don't know the exact number,
But around 1,000?
Lordship, maybe yes.
Maybe 500 or 1,000.
Lordship.
But usually, do villages grow or the towns grow in Nagaland?
Lordship, both, Lordship.
Both.
Lordship.
So you mean to say everyone should be given jobs?
Since an agreement is there, Lordship.
So according to you, no appointment given to the villagers.
Lordship. In the affidavit in opposition, Lordship, the state is includes one document showing that some of the landowners have been given, but then, Your Lordship, I may be from the families of the landowner part, but then, Your Lordship, my appointment was never regular, Lordship, never regular appointment. That particular person was appointed on a talk basis, and then by through TPC, he was regularized.
Where does it say that they will be on regular basis?
Lordship, particular Lordship, compassionate appointment, and then land ownership should be regular, Your Lordship. It's direct requirement, Your Lordship. It should be regular appointment.
The problem is, what does the constitution say?
Yes, Lordship, there are certain criteria, Your Lordship. But then in the notification issued by the certain notification, Your Lordship, I've enclosed, I'll just take you there for short.
Yeah.
Annexure 9, page 26.
Page 26.
Lordship, that is my last annexure. Office memorandum dated 3rd March 2022 issued by the Chief Secretary, Lordship.
OM 3/3/22. Yes.
May I read, Lordship, the relevant part? Subject, filling up of Group T post in the department's corrigendum issued. The procedure of filling up grade 4 posts in the government has been laid down by the Office Memorandum dated 2017 and 24/3/2018. The latter memorandum lays down that applications for recruitment to the post should be called through open advertisement. Number 2, following difficulties expressed by various departments on account of the fact that in many cases, Group T posts such as choketars, malis, and peons are filled by landowners or on compassionate ground and locally at the district, subdivision, or village level. The matter was considered by the cabinet in its meeting held on 9 February 2022 and 22nd February 2022. In order to remove such difficulties, it is hereby directed that the condition of advertisement is dispensed with wherever such difficulties are faced by a department, as long as a fair and transparent eligibility criteria and process is followed, and in all such cases, approval of the government is obtained. Number 3, all requirements as laid on by the government with regard to compulsion appointment of landowners, as well as reservation for backward tribes and persons with disabilities shall be adhered to well following the instruction contained in this OM, Your Lordship.
Yes.
So this office memorandum is very clear, Your Lordship. And then,
In fact, it makes a very clear thing unclear.
Lordship. But then since
It has diluted that advertisement issue. So it has left it to the government to decide as to what to do, depending upon the facts and circumstances of each case.
Lordship.
Where there is a lot of difficulty faced, government can do as it likes, but it has to be fair. That's all. That's what it's saying. Not give it. It's like saying, you don't have to follow the rules. Just be fair.
Lordship.
Transparent. Anyway, that is the one way of looking at it.
Yes, Lordship. But then in the year 2018, Lordship, there is an office memorandum which has been enclosed by the state, Lordship, saying that the landowner appointment should not be in perpetuity, Lordship.
What is wrong?
So after the land transaction was done, Your Lordship, a seal state was executed on
Page, where is that 18, 2008 notification? What has happened to the live streaming?
page 11, Your Lordship, of the affidavit in the possession of respondent 1 to 4.
Yes.
I'll take you to 3B, Lordship. This is OM dated 16 August 2018, issued by the Land Revenue Department.
Yes.
It lays down that it is also clarified that it is not the policy of the government to provide employment or other facility to the landowner in perpetuity. The employment or other facility of landowner, if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner in government service and does not entitle his descendant for further employment or other facility on his retirement from service / vacates the post. That is the only stand they are taken by the state respondents, Your Lordship. But here in my case, my only prayer is that a land transaction was taken between the department and the landowners. Sale deed agreement was executed. Along with that, an agreement was made with a condition saying that grade 4 post should be given to the landowners. Till date, none of the landowners has been given an appointment. And then, as I've said, I've enclosed in my affidavit in reply to the affidavit in the opposition filed by the respondents, showing that one person, Shiri Karinongba, he was appointed to the post of medicine carrier on temporary basis only. And then later on, Lordship,
Where are you saying? Where are you?
my affidavit in reply of respondent 1 to 6 of state respondents.
Page
10, Lordship. Page 10, this is the appointment order. But then here, they are taking the stand that this person is the one who has been given appointment on the basis of land ownership, Lordship.
Yes.
Lordship, here the condition is clear that his declaration will be subject to departmental screening committee, and then accordingly, that particular person must regularize, Lordship. So, at present, when the vacant RSS,
He is from that village.
Lordship,
Was there any advertisement done or before his appointment?
regarding this,
Was-
Lordship,
Yes. Was there any selection process
selection wasn't after his appointment was given, Lordship.
after
After his appointment was given,
selection? What do you mean? How can there be selection after the appointment?
departmental selection committee, through departmental selection,
Regularization, you mean.
Lordship. And then one thing is that when the post of medicine career at District Veterinary Hospital was vacated on 31/5/2023, Lordship. The petitioner here submitted application to the director, which is Annexure 3, stating that I am the genuine landowner. Accordingly, my name was forwarded to the higher authority. And then by Annexure 6, page 22, my name was forwarded along with 5 applicants. And then there, I am its serial number 2, the petitioner, and then the private respondent is serial number 6. After that, the private respondent was given approval, Lordship, without following any due process, Lordship. And then the appointment was given to the private respondent, and then he's serving the department as medicine career. And then if you look into the appointment order, Lordship, the post was vacated at District Veterinary Hospital, Mukokchung. But here in the appointment order, it states that he was, I'll just read the relevant part, Lordship. Shri Supum Wabang, that is respondent 7, is hereby appointed as medicine career at Veterinary Hospital, Mukokchung, under the Chief Veterinary Office, Mukokchung. The post was vacated at District Veterinary Hospital, but then he is serving at Chief Veterinary Office, Mukokchung, Lordship.
Page.
Page 25, Annexure 8, up
Oh,
my writ petition. This is, I've impugned in my writ petition, the appointment
that's
of
the second person. So this is the second person who has been appointed on landowner basis.
No, this is the person, this is the private respondent number 7, who I'm against, who was appointed in place of me, Lordship.
And your this place, where is this? Mokchu only.
Yes. The post was vacated at Veterinary Hospital, Mukokchung, District Veterinary Hospital, but the private respondent was appointed at Chief Veterinary Office, Mukokchung, Lordship.
Huh? So how does it matter?
Your Lordship, District Veterinary Hospital, they have only one veterinary hospital and one in district. But then Chief Veterinary Office, that's a establishment, Your Lordship.
Huh?
That's an establishment, Your Lordship.
In the same land,
No.
in a different land.
Yes, Lordship.
But he was appointed against this post.
Yes.
Appointed as the post of medicine carrier.
Lordship.
Which post is in that?
In my land.
India land.
And but then he was
transferred out. How does it matter?
Lordship, but then it should be
No, doesn't have to serve there all the time.
Lordship. And then regarding the private respondent, Your Lordship, or women, Your Lordship, there are certain rules and regulation and procedures to be followed, Your Lordship. And then the state respondents, they have never advertised the post.
So this Supong Wapang is respondent number 7.
Lordship.
He is from your village. Okay.
He is from different village, Lordship.
Different. That's all.
Lordship, lastly, in their affidavit in the position of private respondent number 7, they have enclosed one annexure OM dated 4th June 2016, page 29, annexure G. Page 29, annexure G, Lordship.
Yes.
Here, Lordship, it number 1, all direct recruitment vacancies occurred in grade 4 posts in the district offices shall be filled up by the indigenous inhabitants of the respective district. I agree with that. That is the only stand. But paragraph 4, Lordship. Shall 4. All vacancies in the above post occurring in the districts excepting the grade 3 post to be filled up by heads of department shall be filled up through open advertisement in a district selection committee shall be constituted by the respective deputy commissioners. The selection committee will be headed by the DC and will include 2 district level heads of office, an administrative officer, and the principal or senior lecturer or of college to be nominated by the deputy commissioner. The committee shall follow the reservation policy for persons with disabilities in respect of 3 and 4 posts, and the reservation policy for backward tribes in respect of grade 3 posts.
So you mean to say
Yes, this is not
the
being followed.
appointment of respondent number 7 is dehors this?
Lordship, well, because number 1 says indigenous evidence. Even me, I'm also an indigenous evidence.
So there was no advertisement.
Lordship, number 4 is not being followed, Your Lordship. So private respondent appointment has to call, Lordship. There should be a fear in transparency for recruiting that post. That is my only submission, Lordship, in this case.
Yes. Yes, Ms. Chang.
I will be relying on my affidavit paragraph 4, 5, and 6, Lordship. As already my has stated, Lordship said.
Tell me one thing, this respondent number 7,
Lordship.
was there any advertisement prior to his appointment?
No, Lordship. Admitted fact that there was no advertisement, Lordship. But his appointment was done through government approval.
Huh?
Government approval,
Maybe,
Lordship.
but then your appointment has to be done. You're appearing for respondent number?
1 to 6. Yes, Lordship.
So who's appearing for 7?
Lordship.
Any advertisement?
There was no advertisement as such, Your Lordship. The government followed other procedures.
What was
However,
that?
my lord, if my lord may kindly consider this aspect also, as far as the power under Article 226 is concerned, this honorable court can weave an extraordinary relief also in terms of the settled principle of law. So as far as the discretion of this honorable court is concerned, I have nothing to say. But the documents show that 2 landowners have already been given appointment, although my learned brother has already been.
Show me those 2 landowners.
Well, I take a lordship to my affidavit. That page, starting from page 20, my lord, annexure P, the private respondent number 7's affidavit. May I first read the
Yes,
the
sir.
letter in annexure P? Page 20. The typed copy is at page 21, my lord. Affidavit in opposition by private respondent number 7. May I read the letter, my lord? Page 21. To the Director, Animal Husbandry and Veterinary Services, Nagaland, Kohima. WPC number so and so. Furnishing of details in regard to appointment of landowners of Veterinary Hospital, Mukukchum. And inviting a reference to your letter number such and such dated Kohima, the 26th October 2023. I have the honor to furnish the necessary documents in relation to the appointment of 4th grade 4 staffs under the establishment of Veterinary Hospital, Mukukchum, located at EMU Ward. All the required documents available in this office. Annexure 1 and a detailed report in the form of chart. Annexure 2, which is self-explanatory on the post of 4th grade post under the establishment of Veterinary Hospital, Mukukchum is enclosed with for your ready reference and further necessary actions. The chart given is the actual 4th grade staff position in the Veterinary Hospital, Mukukchum. It may be noted that the veterinary hospital area is a compensated land. The land under the erstwhile RAIC, that is a regional, what is that?
The regional artificial and insemination center has not been compensated. As per the records available and on inquiry from some of the concerned villagers, it has been found that only 1 4th grade post has been given to Batizar clan of Kansa village. Details are in the chart too. The contract works were allotted at five different times for various activities. Viz. 1. Veterinary dispensary building Assam Hill type. 2. Fencing works. 3. Hospital building now collapsed.
Building collapsed.
Yes, Your Lordship. 4. DTL building. 5. Present veterinary hospital building on top of DTL building. So this were the contract works allotted, my lord. All the details related to this contract works are given in chart annexure 2. All the contract works were done by others who were not the actual landowners, but it has been informed that a percentage amounting to 3% from the total sanctioned amount of each contract works were realized by the landowners from the contractors. This is for your kind necessary and kind information and necessary action, please. Then, my lord, next page is the annexure 2, which, my lord, landowner of the veterinary hospital area, Batizar clan. So, if my lord, look at serial number 1, Karinungba medicine carrier, 12/10/2011, landowner. Then may I take a lordship to the next column again, the next chart. Present 4th grade staff attached to veterinary hospital from RAIC. Serial number 1, my lord. Bandang Wapang, Night Chukidar, Kansa. Appointment 24 June 2019, landowner. My lord, and then if my lord comes down, the last chart, contract works record. Below that, there is a one line.
3%.
Yes, my lord. From all the above contract works, the Batizar clan collected 3% from the contractors. So, my lord, if we look at the prayer of the writ petition, they have not asked for other reliefs, except that the appointment of the respondent number 7 should go, and they should be appointed on the basis of land ownership. And if we appreciate the 2018 notification of the state, my lord, it is clear that there can be no appointment in perpetuity. So if there are 1,000 landowners, it's everywhere, even in my village also. After the 2018 notification, if one landowner has already been appointed, assuming that the land may belong to 4 or 5 families or 10 families, one appointment, my lord. After that, the appointment in perpetuity has been discouraged. And I have authorities also of this Honorable Court to show that further appointments in perpetuity cannot be granted.
Sure.
My lord, 2025 SCC Online Gauhati 2038. May I take a lordship to paragraph 16 and 17. This is a recent judgment of the Honorable Court.
Yeah.
Paragraph 16, my lord.
Yeah.
Sri Limawapang has further submitted that when the father of the writ petitioner had already admitted in WPC such and such of 2001 that employment had been given to his family, the petitioner cannot state different facts now. On this ground alone, the writ petition is liable to be dismissed on the ground of making false and misleading statements. In order to support his argument on the question of maintainability, Learned Counsel for Respondent number 5 has referred to the case of Prestige Lights Limited versus State Bank of India, 2007-8 SCC 449, where the Honorable Apex Court at paragraph 33 and 35 held that it is thus clear that though the appellant company had approached the High Court under Article 226 of the Constitution, it had not candidly stated all the facts to the court. The High Court is exercising discretionary and extraordinary jurisdiction under Article 226 of the Constitution. Over and above, a court of law is also a court of equity. It is therefore of utmost necessity that when a party approaches a High Court, he must place all the facts before the court without any reservation. If there is suppression of material facts on the part of the applicant or twisted facts have been placed before the court, the writ court may refuse to entertain the petition and dismiss it without entering into merits of the matter. Then paragraph 35, my lord, it is well settled that a prerogative remedy is not a matter of course. In exercising extraordinary power. Yes, your lordship. Then para 17.
Okay, basically, what does it basically say? Just go down to the brass tack.
Then, my lord, para 17, my lord. The court has considered the submission of the learned counsels for the parties and examined the records available before the court. The claim of the petitioner being a landowner is based on the agreement dated 13/1/1988. It is not disputed that the name of the petitioner's father appears at serial number 4 amongst the landowners. The policy of the state government with regard to the appointment on land ownership basis is set out in a notification number such and such, 5th March 2018, at Annexure D to the counter affidavit of the respondent number 1, 2, 3, and 4, and paragraph 3A and 3C.
Okay, next,
Yes, my
next, next.
My lord, WBC number 138 of 2022. This is also the judgment of this honorable court. May I take your lordship to paragraph 11?
Yeah.
This court, having given an anxious consideration to the notification dated 5/3/2018, and further taking into account that a brother of the petitioner as well as his cousin brother have been duly appointed in the state office of the additional deputy commissioner, wherein the building stands on land ownership.
Okay,
basis.
next.
Yes.
How many judgments have you got?
Lord, only a few. And in fact, your lordship.
Only a few means how much?
4, your lordship.
Hey, give me all in one go.
Yes, your lordship.
No point
The
in-
judgment I just referred, here I was the petitioner, but
So you lost.
yes, your lordship, I lost.
So now you want that losing streak to be turned into a win here. On the
It has
basis.
become the settled position of law, my lord. Now, this is WBC number 89 of 2023, paragraph 18 to 20, my lord. May I take a lordship to paragraph 18?
Okay, got it. Then
Then your lordship, 2000 WBC number 302 of 2017, which the copy is already given to your lordship. I'm referring to paragraph 17, my lord.
okay.
Then, my lord, whether the petitioner can be considered an aggrieved person or not, on the question of locus, may I give one judgment? Because when all the benefits have already been availed, whether the person can be an aggrieved person approaching his own court, I have one authority to place before your lordship. Two, my lord. One is 2013 4 SCC, page 465. I'm relying on paragraph 9 to 12, 17 and 19, my lord.
What is that? Yaqub Khan? What is this?
Your lordship.
Ayub Khan.
Yes, your lordship.
Ayub Khan Nur Pathan.
Yes. Pathan, yes, your lordship.
The aggrieved person, yes.
Yes, your lordship. Then, my lord, 2022.
That's a settled position. That is the general law.
Your lordship.
That only a person whose legally enforceable rights have been violated can approach the court. And who can be said to have a cause of action.
My lord.
That's a settled position.
Then, one judgment of this honorable court, Gauhati High Court, your lordship, 2022, 2 GLT, page 555, paragraph 5 to 7.
To what effect?
Your lordship, this is also on the same question, whether the petition. Paragraph 5 to 7, my lord.
Yes.
Hear it, my lord.
No, it is again same thing.
Yes, your lordship.
That's all.
That's all, your lordship.
I just wanted to know, these 3 writ petitions, there are 3 petitioners.
Lordship.
Vying for the same post.
Different post, lordship.
Different posts.
Three different posts.
3 different.
But in the same office, my lord.
Yes.
Yeah, they are vying for 3 different. Now, in the second writ petition, we challenge another person's.
Lordship.
absence.
Yes, your lordship.
Challenge again number 7.
Yes, Lord.
Yes, your
In
lordship.
all numbers.
Same.
Number 7.
And none of them had advertisement.
Lordship, one thing to be for clarification, Your Lordship. Now, my learned friend is shown one annexure before this honorable court, Your Lordship, annexure to page 22 of the respondent 7, showing that landowners have been appointed, Your Lordship. My case is its serial number 1 only, that is the, and then the other regarding prison for grade staffs attached to veterinary hospital from REIC, Lordship. That's different landowners, Your Lordship.
Hmm?
Page 22 of your,
RIIC,
that's different, Lordship, yes. My land, it's serial number 1.
In Nungba,
Yes, Lordship.
that's the only one.
That is the only land, Lordship.
That's the only landowner.
Lordship, actually, he's a part of the landowner, but in Lordship, his nature of appointment was never given on the basis of ownership, Lordship.
Okay, never came on.
Yes, never given on the basis of ownership. The appointment order speaks itself,
You
Lordship.
see, Mr. Kasal, what is your right? You were born,
Lordship.
when you born? What is your age now? You're 23 right now. You were born sometime in 2002.
Lordship.
This land was given in the year 78. You
Lordship.
were nowhere in the entire universe, you were nowhere.
Lordship, had he fulfilled the agreement, Lordship, till date? No.
No, right. Very well. How can you be said to be aggrieved?
No, Lordship, agreement is.
You are not a landowner in 1978. You've got no right.
It's a problem all landowners in different parts are also facing, not just the petitioner.
You see, because I can understand if you were a landowner there in that time. But most probably you're the grandchild or something, grandson of those landowners that time.
Lordship.
Or maybe the son, maybe, I don't know. But where is the right? Otherwise, all agreements that are made will continue for generations and generations. You know, the changing world.
On that point, given the circumstance where I'm not on the side of the petitioner, but it's not a problem just faced by the petitioner, but everywhere. So if no appointment has ever been given, and there is an agreement.
If no appointment is given, they should give, but
yes,
that is also subject to the condition that the appointment is given during the lifetime of those landowners. Not to, otherwise someone will claim, supposing no claim is made for 1,000 years. Then what happens? After 1,000 years they'll claim. So where do you draw the line? Where do you draw the line? You have got to draw the line somewhere. I don't think you have got a case, Mr. But let me hear, Madam.
Lordship is for my applicant opposition, Lordship. Point, I'll be relying on 4, 5, and 6, Lordship. Paragraph 4, 5, and 6, Lordship. So which I have stated that it are compensated land, Lordship.
Somehow 22,300 cents. Okay, so we are for government. And we win para 4, 5, and 6.
4, 5, and 6, Lordship.
4, 5, and 6 of AIO.
AIO.
Of respondent number
1 to 6.
Respondent 1 to 6. So you have said.
I've stated that it's a purchase land, Lordship, compensate.
One grade for post order.
Paper process already been able to Lordship.
And what about the 3% contract? No. That he has given. That 3% of the contract price, that you have not mentioned.
I've not stated, Lordship.
Anyway, the prayer is not for the prayer is only for post. Correct. Right, Mr.
Subhamwati.
Supangwati, learned counsel for the petitioners in all the writ petitions. Also heard Miss Chung, L. Chung,
S. Chung.
S. Chung. S stands for?
S was the done.
S. Means for Superman, superstar. Huh? What's your name?
Sipong Lamla.
Superb.
Sipong Lamla.
Sipong Lamla. Is Chance, learned government advocate for the response number 126. Mr. Joshua appears for response number 7. I wanted to dictate in your presence. You have time. You just dictate so that at least the facts are not wrong. Okay. All the three repetitions are being disposed of by the president, by this common order. That will end. The facts of the case, no, the petitioner's case is there. The petitioners should be appointed to various grade 4 posts under the district veterinary hospital YIMU ward, YIMYU ward, Mokokchung, Nagaland. In as much as they are the bona fide landowners on which the district veterinary hospital had been constructed. Next one. The petitioners council submit that land for the district veterinary hospital had been donated to by Shri Sai Sat Suba. This is page 15, huh? Head of clan of Batizar clan. No, head of Batizar clan. Head of Batizar clan of Khensa village. Khensa. On payment of land compensation on 23/6/1978, with the additional terms and condition. Number 1, appointment of 4th grade staff should be offered to landowner. Number 2, contract works should be given / awarded to the landowner. Next part. The petitioner's council submits that instead of landowners having been given appointment as grade 4 staff in the district veterinary hospital, EMU ward, Mohokchung, Nagaland, the same has been given to the respondent number 7. No, in all the 3 petitions. He submits that the respondent number 7 in all the 3 petitions are not landowners, and as such, their appointments should be cancelled, and in their place, the petitioners in all the 3 petitions should be appointed as grade 4 staff. The learned government advocate submits that the land of the petitioner had been bought by the state government on the basis of a sale deed executed on 23/6/1978, where all the right, title, and interest of the land was transferred to the state government. The sale price of rupees 22,320 was given to the landowner and one landowner had already availed the condition of appointment to a grade 4 post in terms of the policy laid down under Office Memorandum Number LR/Land-PLCY/5-26/2011 dated Kohima, the 16th August 2018. The next paragraph, the learned counsel for the state respondents further submit that as per the OM dated 16/8/2018, employment can be given only to the, or can only be limited to the first person appointed as landowner and does not entitle his descendants from claiming further employment on the basis of being a landowner. As such, the petitioners cannot claim appointment on the basis of landowner policy. And on the basis of being a landowner, as one person had already been appointed. Next part. Mr. Joshua, the learned counsel for the respondent number 7, submits that two persons of the bracket landowners of the land.
What is our clan?
Batizar clan, BATIZAR, Batizar clan, have already been appointed as grade 4 employee on the basis of the sale agreement executed on 23/6/1978. First of all, he further submits that as can be seen from the letter number MV/2023-24/1/417, page 21 of the affidavit of respondent number 7, dated 1/11/2023, issued by the Chief Animal Husbandry and Veterinary Officer of Mokokchung, Nagaland, along with the annexure, shows that for the 5 contract works that had been made on the land donated to the donated for the veterinary hospital, the Batizar clan had collected 3% from the contractor bills. As such, all the terms and conditions of the sale deed had been executed and completed by the state respondent. Thus, there was no question of, there is no question of appointing the present petitioner as landowner. Especially when the government notification dated 5/3/2018 does not permit appointment on landowner basis in perpetuity. That's all. That's all. One more thing you write, huh? For Mr. Supamwati, petitioner, one paragraph. The petitioner's counsel submits that the perusal of the appointment orders of the respondents in all the three lead petitions show that their appointments had been made without any prior advertisement being issued for the post of, what was that in
Medicine carrier.
medicine carrier bracket WPC 215 of 2023. Then number 2, you write what's
Sweeper.
sweeper WPC 216 of 2023, and number 3
Beyond on 20.
beyond
Beyond. 217.
bracket, WPC 217 of 2020. Full stop. He submits that in terms of the OM dated 4/6/2016, that is the page 29 of the affidavit of the respondent number 7.
Paragraph 4.
Huh?
Paragraph 4.
Paragraph 4. Paragraph 4, comma. The posts have to be filled up through open advertisement and through a duly constituted selection committee. However, the petitioners who are eligible to be considered for the above 3 posts could not participate in the selection process due to the respondents not issuing any advertisement for the same. That's all. Next, I have heard the learned counsels for the comments. To a query made to the counsel for the respondent number 7 as to whether the appointments of all the 3 respondent number 7 had been made on the basis of an open advertisement issued by the respondents, state respondents. He submits that no advertisements had been issued for the same. Correct?
Yes, Your Lordship, and if my lord may kindly recall, this however not the prayer of the petitioner in the writ petition to ask for, against the notification which I have annexed. In all fairness, I have annexed. However, Your Lordship, they only want the appointment, not because they have not been able to participate in the selection process. They want direct appointment, which goes to appointment in perpetuity.
But then your appointment is not correct. Everyone should be around. Probably you'll be selected again, but it should follow the procedure. We don't know.
Your Lordship.
We don't know. They should be fair. Government hopefully will be fair and they will do it through merit.
Madam.
So, okay, that's all. Miss S. Chan, learned government advocate, also submits that no prior open advertisement had been issued before appointment orders had been issued to the respondent number 7 in all the 3 reports. Okay, next paragraph. Okay, we'll do it later, I think, because it'll take some time. So we'll do it, but we'll keep it as CV or we know the decision. Some more hearing is there, no, today?
I believe so, Your Lordship.
Okay, just make it CV, just, sure. What? Any problem? Huh? Today we'll try and finish it, okay. Because I like to dictate when you all are there. Otherwise, mistakes, that can be corrected.
Lordship. My lord has already reported all the facts of the case as it is. So on low points, present.
No, then what happens, once I go there, then I have to again acclimatize myself with the pages of it. Anyway, good enough. And these are your judgments. Oh, wait, these judgments are here. Okay, we'll consider this.
Can I prove, my lord?
At two, why not?
My lord.
Yeah, at two, we have got item 23 has been adjourned. 27, domestic violence. Custody. Oh, okay. Huh? So this village council is interfering. Right. Okay.
Bless you, Lord.
Yes. Oh, what is this? Acha, this is yours.
Yes, Your Lordship.
Oh, the dictation part.
Yes.
Later, I'll finish that, those other pieces first. Basically decided.
Yes, Your Lordship.
Decided, basically dismissed. Your appointments are cancelled.
Lordship.
So, operation successful, both failed.
Well. Lordship. I couldn't make that.
Who's the petitioner? You're the petitioner, correct?
Lordship.
You are challenging the judgment of the Dobashis
Lordship.
court,
Lordship.
correct?
Yes.
So your case was that dispute was with regard to the compensation.
Lordship.
So the Dobashis court in favor of you. No, 60, 40.
Lordship.
Then you went to the DC.
Lordship, the petition is not me, Lordship. I'm not well versed with the case, Lordship.
Huh?
They still haven't been here from the order of the Tobashi.
What day?
From the order of district Tobashi court, they came forward as a writ petition under the
Okay, they did not go to a Dobashi court earlier.
first original jurisdiction Tobashi court
Dobashi court
of Ralan.
of Ralam.
Yeah, they had a spot verification, they passed the order. Against that order, they came to this PC, but PC said Tobashi is the appellate court, so they said to district Tobashi's court. That is district Tobashi's court, as per customary law. Then without going to the sit by submission, we can't go to the civil court. They get straight over here under the cover of 226. And this honorable court has into three of
Let me see let us see the Dobashi court order. Which page?
Page 80 lodge
80.
of their petition.
This is the first Dobashi court order. No, this is the district.
First Tobashi will be page 44 to 47, I think.
Page 47.
Uh,
44.
Wait, let me see the pages lodging. Page 44 to page 47 is the first Tobashi court. In the
Cannot
petition.
Okay, page 44. Basically 44 only, 44 and 45.
44, 47, English translation, English translation.
Oh, one is Lotha.
Yes.
Okay.
To enable the court to understand that we have they have translated and then they have seen up.
The aggrieved parties have every right to go for appeal if they are not satisfied by the judgment order by deposing before the DB's court Ralan. So, the Bashi court. So, so let us see the law by which they went to the DC's court, the DC.
They are supposed to go to address to district head Tobashi court part instead of addressing head Tobashi court, district court.
Show me the law.
No, it is given the lordship. Right.
Where is the letter of the DC that it should go before the district Dobashi or district court or whatever?
Usually they endorse only.
Okay.
Usually they endorse.
So there is no order.
Yeah, there is no special, but they just endorse whenever papers comes to him.
To the district customary court.
Lordship.
Let us see the law which says that Dobashi court order should be heard by a district customary court.
Lord, in that case, we have
Show us the Administration of Justice Rules 1937.
Wait. Lordship, GLT 2013 volume 4 at page 113, para 3 subclass 2 is written.
Okay, written. Sure. Para 3.
Yeah, it is written notwithstanding such a repeal. Lordship, read that. It's at page 113.
Para?
Para 3 subclause 2, notwithstanding such a repeal.
No, this is okay. This okay.
So this is the one which I was referring to. Then
this is with the provision of the rules for administrative justice in Zipsagar, Naugam, and Mikir Hills.
For all, this was the one which I have referred.
Is this applicable in the state of Nagaland?
Everywhere, sir.
No. Mizoram has got separate 1937 rules.
No.
And 1952 also. We have got separate. This is for Mikir.
Lordship, then let us come to para 21 of the same order. It is given here about Nagaland. It covers the entire Northeast.
Mr. Akito, can you help us? What is the provision of law under which you go from a Debashish court to which court do you go?
Can we have a copy of the 1937 rules?
Where's my copy?
There is a blue book by Justice Zilre. Do you have a copy?
Where's my copy?
Yes. Please, Lordship, give me another copy if you have another copy.
One more, you've got one more copy.
Yes.
Lordship, I have given a copy of one judgment passed by this.
Let us go to the law. The judgment too will decide later.
Your Lordship, turn to page 27, chapter 4, Civil Justice.
Yes.
The administration of civil justice in the state of Nagaland is entrusted to the Deputy Commissioner, Additional Deputy Commissioner, Assistant to the Deputy Commissioner, customary courts constituted under Chapter 4A, but Chapter 4A is now in abeyance, Your Lordship. So we can exclude this portion. Chapter 4A of the rules, Dubashis and other village authority may be appointed by the state government from time to time. So these are our authorities. Then next page, 23A. Rule 23, the Dubashis henceforward shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner. So Dubashi, they do not have any authority to take up cases independently, only if referred to them by the Deputy Commissioner. Then 24 is about the village councils. Then 25 is also about village councils, etc. Then 26 is also about the proceedings. Then 27, 28, all same, my lord. Then 29. The Deputy Commissioner and his assistants shall not ordinarily hear suits against a tribal by tribal court, etc., etc. Then 24.1 below is about the filing of the suits. Then 25.1 is about judgment recording evidence. And 30 is about referring parties to a panchayat if they are tribals belonging to the state. Then 31, this is a relevant rule, Your Lordship. An appeal shall lie from the decision of the Mozadar, Gaunbara, chief headman of Khels, Dubashis, or other duly recognized village authority to the tribal court whenever constituted. So there is no tribal court right now. There is no tribal court right now. To the Deputy Commissioner or his assistant. So the appeal lies to the Deputy Commissioner or his assistant. So from the Dubashi's court, Your Lordship, the appeal will lie to the Deputy Commissioner or his assistant. So the Deputy Commissioner or his assistant cannot again refer the appeal file back to the Dubashi. The Dubashi has got no appellate jurisdiction. That is a decision of the division bench of this Honorable Court, Your Lordship. After going through the entire provisions, this Honorable Court has come to the conclusion that the Dubashis under the rules do not have any appellate authority. So which means any decision of the Dubashi's court will have to be decided by the Deputy Commissioner himself or his assistant. If that division bench judgment, Your Lordship requires, I think another. Yes. The division bench judgment is here, Your Lordship. In fact, in this division bench judgment, the entire scope of the rules has been discussed.
Yes, you see, there are two aspects. The first is that the Dobashi court had passed an order. Now, that order does not appear to have been passed on the basis of an endorsement of sending the issue to be decided by the Dobashi. Number one, if we hold that the first order was correct, is it correct according to you, the first order, Dobashi order? Is it correct?
Lordship, even though it was not absolutely as per nature of justice, why? Because Tobashi first court, they went for spot verification.
No, Mr. Counsel, it's a question of law. Let us
No,
not.
that is why now, although this is not a land dispute case, but it is only compensation. And the pipeline is going through my field, through my land. I'm a recognized village. But the person who is not a member of that village, who was is claiming my
You
compensation.
see, Mr. Counsel, you're missing the wood for the trees. The issue is not that. I'm not on the issue of who should get the compensation or who should not get the compensation. The issue is this, whether the first Dobashi court order was correct or was it beyond beyond his jurisdiction? Would it have passed the first order? Because it appears from this that whether can a dispute be directly referred to a Dobashi court by the litigants, by the parties, or does it have to go through the Deputy Commissioner's office?
Lordship, in the present case,
It be the law. Don't tell me.
in the present case, Lordship, there is no dispute of any nature, but the present writ petitioner had made case on it.
You're not getting the point. No point. And yes, you tell me, can a Dobashi decide a dispute without it being referred to it by the DC?
I think dispute which is usually by the DC only, so basically can help you.
Only so Dobashi can decide a matter only if the matter is referred to it by the DC. Correct?
That is one part. That is
Now, so
original transaction.
original. So in the first order passed by the Dobashi, in where it said that 60-40 should be given. There was it, so was that as per the law? Was it referred? This page 45, 46, 47. Was this is correct? Was the procedure followed?
Yeah, I think appropriately answered by the petitioner. And at the same time, if the appeal is perfect.
You are the DC, you are supposed to know everything.
That's why
You don't have.
I'm fair for that.
Okay, let's give them time. Mr. Counsel, there are two things. You please hear me out. If the first Dobashi order was correct, I'm not saying it is right or wrong. I'm saying that if it had the power if it had correctly exercised that power, whether it was in your favor or not in your favor, that's a different thing. But if it had the power to do it, then the second, that order can be challenged and decided only by the DC. The DC cannot refer it back to the Dobashi.
In case of appeal.
In case of appeal.
Yes.
So DC, so in that case, petitioner is quite correct in a way that the second Dobashi order is wrong. However, if the first Dobashi order is wrong or beyond its jurisdiction, if the matter had not been referred to it by the Dobashi, by the DC, then the second Dobashi order is correct. And in which case, you'll have to file an appeal before the DC again. You get it? So, if you file, and if the first Dobashi order was correct, and the second Dabashi order was without jurisdiction, then what has to be done is you will have to file an application under 227 saying that the second Dabashi order was beyond its jurisdiction because it had already been decided in the first Dabashi order. So you cannot, just because DC has endorsed it to you for a second time, you cannot decide again. So for that, 226 is not the answer. 226 is an answer. 226 will not apply because Supreme Court has said, the Radha Shyam case, that to challenge an order of a court, 226 is not the procedure. You have to challenge it by way of appeal or under 227.
Lordship.
You get my point?
Lordship.
So if Dabashi order number 1 is correct, then the second Dabashi order is wrong, for which you file a 227 petition challenging the second Dabashi order and the DC order, endorsing it to the Dabashi side and directing that the appeal should be heard by the DC.
Lordship.
However, if the first Dabashi order is wrong, and then that means the second Dabashi order is correct because it was referred to by the DC. In which case, you have to file an appeal before the DC, not here. So this petition under 226 anyway is wrong in both scenarios. You get my point? Only thing is, you have to find out whether the first Dabashi order was correctly, decided, meaning to say whether that matter was referred to it by the DC. If it was not referred to by the DC, then that order is wrong. If it was referred to by the DC, then the second Dabashi order is wrong. But your writ petition will go anyway. You'll have to file a fresh. If the second Dabashi order is wrong, then you have to file a 227 petition.
Nothing there, other 226.
226 will not, either way, 226 will not. Only thing is that you have to clarify. We can leave it for Thursday. You just clarify one thing. Whether the first Dabashi order had been passed on the basis of the issue being referred to it by the DC. That's all. Because the second we don't have to, we have to know only the first Dabashi order. Whether the first Dabashi had been, court had decided the issue after the matter was referred to it by the DC. That's
Lordship, all the cases are not treated by the Divinity Commission. But the fact that this is a customary law. This was done all in customary law. So that is why Sumudo original application lies with the Dabashi. After the Dabashi court decides, then it goes to the district appellate court. And for that reason, Lordship, since there is an avenue in this honorable court in WPS says.
No, Mr. Counsel, please read 23A. Don't read only judgments. Please read the law, and the judgments will clarify the law. You have to first read the law. Have you read this? Have you read these rules for administration of justice in Nagaland 1937? 23A. Please read 23A.
But original jurisdiction lies with the Dabashi court, Lordship.
Maybe, but where? Show me. I'm not saying it does not lie. I'm saying it lies, but there is a procedure. There is a procedure how to do things. Okay. There is a procedure of how to go about things. Say you want to give an exam for officers. You're not listening also. So it's supposed to be a two-way traffic, Mr. Counsel. It takes two to tango. Very difficult to tango alone. Please read 23A.
We after rule 1. I have not got the.
Okay, give it to me.
The Tobashi henceforth shall try and decide such civil cases only as may be referred to them by the DD commissioner or the DD commissioner or assistant to the DD commissioner as needed. Lordship, in this case, civil STO, deputy commissioner means ADC.
Correct.
Assistant means civil STO.
Correct.
It was endorsed by STO Civil Ralan to his Topashis
Okay.
to take up this case.
For the first case.
First case.
The first case.
First case.
So if that be the case, then the second, then that means then the second Dobashi order is wrong. How can the Dobashi decide a matter twice?
The Topashis, the clients, the present petitioners, they addressed to, since initially it was addressed to STO Civil, again they addressed to deputy commissioner and the deputy commissioners endorsed on the petition.
So we will set aside the second Dobashi order and the endorsement, and we will tell them to go to an appeal. Simple.
Yeah, Lordship, in case on the first Topashi's case, which is endorsed by the STO Civil to the Topashis. So if the petitioner was agreed, then they can.
No, he's not agreed with the endorsement. He's only agreed with the order.
Agreed.
And that order has to be decided in appeal by the DC. Now the DC, instead of deciding that, has sent it to the Dobashi, which it should not have done. So we are going to say, we are setting aside the second Dobashi order and let the DC decide the matter.
Yes, that is so sorry.
Lordship, this matter can come up on Thursday, Your Lordship. Yes, so that the leading council can come and review the matter, Lordship.
Just give me that. I'll let me reflect. Let me write at least the order so that on Thursday we don't have to do much thinking. Heard, Mr.
Meadow Vero, Lordship.
Meadow
Vero,
learned counsel for the petitioner. Also heard Mr. Ibtim Song, addition AG. AG. For respondents number 1, 2, and 3. Mr.
P. Pius.
Huh?
P. Pius Lotha.
P. Pius Lotha. For?
Respondent number 678.
678. Okay. Uh, 678. Okay. I've got a friend in Wokha, in Lokha.
I have
Makes good meat also. Makes good dishes in this banana leaves type.
Yes.
Okay, right. This writ petition, just a minute. Huh? No, this petition under Article 2 to 6 of the Constitution has put to challenge the judgment and order
Page 80.
the judgment and order dated 11/7/2025 passed by the District Customary Court bracket Dobashi. What Dobashi? Dobashi, huh? Comma, by which the compensation for constructing IGGL gas pipeline.
IGGL pipeline, gas pipeline.
That's what I said. Gas pipeline has been directed to be distributed between the huh? Which Lee Cheyenne village. Lishayan, the Cheyenne village, and the petitioner. Huh? And the
Petitioner's name is Teplobithan.
yeah, don't need to. And the petitioner in the ratio of 60% and 40%. Full stop. The case of the petitioner is that he is the owner of land on which the IGGL gas pipeline has been constructed. And though he should have been given the entire compensation amount, the impugned judgment and order has awarded him only 40% of the compensation. The petitioner's counsel thus praised that the impugned judgment and order should be set aside. And the petitioner should be awarded the entire compensation. Next paragraph. The petitioner's counsel also submit before that, don't say anything. The counsel for the respondents number 6, 7, and 8. 6, 7, and 8 submits that the IGGL gas pipeline did not touch an inch of the petitioner's land. And the 40% of the compensation that has been awarded to the petitioner by the district customary court bracket Dobashi is only by way of what? By way of what? Appeasement, you said.
Appeasement. That is what we are alleging.
Appeasement, why should you appease him? His land is not affected.
Appeasement, because they were not affected.
By way of appeasement. By way of appeasement. He also submits that the land in question belonged to the respondent number 7.
6, 7, 8.
6, 7, and 8.
Yes.
And not to the petitioner.
Not to the petition.
And not to the petitioner.
As per spot verification.
As per spot verification conducted by the SDO Civil, Ralan, RALAN.
Then Tobashi.
And the Dobashi.
And in the presence of both the parties.
In the presence of both the parties.
Right.
He accordingly submits that no case for interference has been made out by the petition. Next paragraph. The learned additional lady has been asked as to whether the dispute between the parties in relation to the compensation payable to the petitioner, which had been decided by the Dobashi court by judgment by the earlier judgment and order dated 10/12/2024, and the subsequent appeal decided by the district customary court bracket Dobashi on 11/7/2025 had been referred to the said courts by the office of the Deputy Commissioner or his officers in terms of section 23 capital A of the of the rules for administration of justice and police in Nagaland, 1937. He submits that both the decisions had been made by the Dobashi court on the basis of the same being on the basis of the dispute being referred to them by the office of the deputy commissioner and his officers. Next paragraph. I have heard the cause for the parties. To a pointed query made to the counsel for the respondent number 6 to 8 as to whether the two decisions made on 10/12/24 and 11/7/2025 by the Dobashi courts, was in pursuance to a reference made by the Deputy Commissioner and his officers under Section 27A of the Administration of Justice and Police in 1937, the said council has replied in the positive. Next paragraph. The submissions made by the counsels for the parties thus clearly show that the dispute between the parties has been decided twice by the same court.
Lordship, one is the word original, and then as per customary for PC. So, appellate, one is the appellate.
How do you say appellate? With this, there's nothing here which says appellate because it's out here. 23A says that
In the customary court, we call it subsidiary, that is which are under TC, and district court is the Tobashis, which are with the deputy commissioners. So we have this subsidiary as well as the appellate court, that is as per customary court.
you see, 31 says, 31 says, an appeal shall lie from the decision of the Mauzadar, Gaunbura chief, headman of Khels, Dobashis, or other duly recognized village authority to the tribal court whenever constituted or otherwise. So is there a tribal court in Nagaland?
No, we don't, we have only Tobashis court.
So if there is no tribal, then where does it go?
So we call subsidiary, but is next to the district court. No, those who are in under civil and those who are under ADC. So Tobashis have courts under this SU civil. That is why initially it was made before ADC. But in all the cases, ADC is not there, SU civil is not there, ADC is out there. That is why we call these two Tobashi courts a subsidiary. Then the final appellate court is the district, we call it district Tobashi court, where all the appeals decided by these Tobashi courts go to the district court. That is a prevalent situation in that.
Whether the village court or the village itself or it's not TC.
Correct. So you cannot have original jurisdictions for already that original jurisdiction. So you mean say that district court is the appellate authority according to you?
Whatever they decide they put there, because
Mr. Counsel, the problem is your arguments are not based on the law or something to support your submission. You are saying something I can understand. In olden times, if someone says, then we believe him. But now the law is that it has to be based on something. There has to be an existence of some provision of law. Otherwise, we cannot. We are saying something in thin air. Is there any tribal court, first of all?
There are no such, I have in fact discussed, it also the court lordship, not relevant to this case. I have discussed with the CM and then he said that he will constitute a committee for all this. He has told me. So.
I need the help of Mr. Akito again, I think.
So that is what he has told me. There will be committee to constitute this,
So, Your Lordship, Part 4A, as I was saying earlier, under the rules, was kept in abeyance. So that Part 4A deals with the creation of district customary codes, subdivision district customary codes, etc., etc. That was kept in abeyance. That has been amended recently, and these so-called classes of customary codes have been set up, but it is yet to come into force.
Where is that? We don't have that.
I don't have that. But there are no district customary codes as of now.
But
There
I
are no
think-
travel codes as of now.
To clarify that carefully, otherwise it might cause confusion.
contemplating. The state government is contemplating, they have decided, but it has not come to reality.
It's here. Now, before I pass it on, Your Lordship, this is the rules for the administration of justice and police in Nagaland, First Amendment Act of 2025. So this act may be called the rules for the Fifth Amendment Act, etc., etc. It shall come into force on such date as the state government may by notification in the official gazette appoint.
Okay. And you said that this 23, this chapter 4.
No.
No, which one did you say that has been kept in abeyance?
Yes, ma'am. It is there in the rules itself.
This 23?
Yes. No, not 23, chapter 4A.
Chapter 4?
Chapter 4A, which earlier dealt with the subject matter of the Fifth Amendment. Chapter 4A. Show me.
Huh?
So I
The administration doesn't state on page 27. The administration of justice is so constituted may be appointed by the state government by 4A. Provided that shall be by the 4A. That's 4A. 4A.
Chapter 4 is at page 51, Your Lordship.
51.
Yes.
Okay, yes.
Yes.
So there is no court. There is no district customary court.
Yes, no district customary.
Lordship, let me highlight the point. If we see that.
Mr. Counsel, you see, that decision, that district customary court which passed the order is not in existence.
Lordship, in the petitioner's petition at page 80, the headline is very Government of Nagaland, the District Customary Court, Office of Deputy Commission, Bokar Nagaland. It's very clearly given where the head Kobashi has countersigned in his order. So then it cannot go to the detail again, Lordship. Because the customary law empowers the Kobashi to pass all these orders.
You're not, I don't think you're getting the picture, I think. Mr. Counsel.
What? Now they have come against this order. Did they say that they are not entitled to pass the order? Did they say that the district customary court doesn't exist?
They don't have to say does not exist.
No,
If it does not exist, does not exist.
No, but
Just because they do not know whether it exists or not, does not change the fact that it is not there.
Your Honor,
It is like saying, I will kill this person, and he kills him. And then later on, the court says, why did you kill him? Don't you know it's a crime? No, I don't know. I didn't know. Doesn't change the fact that murder is a crime. You don't have to know.
Lordship, when we read this article.
This is ignorance is no. There is no.
Article 321A, it clearly gives the power
Either
to
way,
the
you see,
customary courts.
huh?
It clearly gives the power to the customary courts for four different reasons.
No case, Mr. Counsel. I say the thing is that let the DC decide. That's all. Let the DC decide the issue because the district customary court is not in existence. That's all.
They came with the day only by the movement to 2025.
That is when it's the date of effect will be given by notification in the gazette, official gazette. So that is not given. Then correct. So only one Devashi code. There is no district customary code.
Lordship, that may be clearly reflected so that we can digest with the comment. How about this?
So now what will happen is we will set aside the order, Devashi, and we will tell the DC to decide the case. That's all.
Much it needs another debate in here.
No. Thank you for clearing the cobwebs. And a special thanks to Mr. Akito. He helped clear the cobwebs. Yes, anything? Okay, well.
I'm just my submission that they have not come clean hands to dismiss this writ petition. That is my submission on all this counts.
Anyway, let us not go into those small issues. You're a experienced man. We should not get stuck in, small things. Right, where are we? No, well, has been decided by the Dobashi court and the subordinate and the district customary court. The issue in the present case is whether the appeals from a Dobashi court would lie to the district customary court. Full stop. This is this section or what is it? Rules. Rule 23 of the 1937 rules provides that the administration of civil justice in the state of Nagaland is entrusted to the Deputy Commissioner and his officers and the customary courts constituted under Chapter 4A, Roman 4, of the rules, Dobashis and other village authorities may be appointed by the state government from time to time by notification in the official gazette. Gustav. Section 39 of the uh, 1937 rules provides that there shall be 3 classes of customary courts in the state of Nagaland, which will be number 1, village courts, number 2, subordinate district customary courts, number 3, district customary courts. This is at page, okay, it's here in this book. Next paragraph. In the next paragraph, the state of Nagaland, the Nagaland Legislative Assembly on 7/3/2025 passed the rules for administration of justice and police in Nagaland, bracket 5th Amendment, bracket close. No, 5th Amendment. No. 5th Amendment, bracket close Act, 2025, which provides that Chapter 4A of the Rules for Administration of Justice and Police in Nagaland. What is this Third Amendment Act? Third Amendment Act is here. This Third Amendment Act 1984 shall come into force on such date, as the state government may, by notification in the official gazette appoint. It is an admitted position in the bar that no notification has been issued in the official gazette till date as to when Chapter 4A of the 2015 rules, the 1937 rules would come into force. As such, as on date, the district council court, the district customary court is not in existence. However, the district customary court has passed the impugned judgment and order dated 11/7/2025. Next paragraph. The above being said, Section Rule 23A of the 1953 rule states as follows. 23A and and 31 of the 1937 rules provides as follows. Okay. A perusal of the above two rules clearly goes to show that the Dobashi can try and decide such civil cases as referred to them by the Deputy Commissioner or his officers, and that a decision of the Dobashi shall be appealable to a tribal court whenever constituted. However, a tribal court has not been constituted till today, as has been stated by the counsels for the parties. On reading section Rule 31, it thus becomes clear that an appeal from a Dobashi court shall lie to the Deputy Commissioner or his assistant, and it cannot, and the said appeal cannot be relegated to some other authority by the Deputy Commissioner or his officers. Next paragraph. In the present case, the next paragraph. The facts of the present case is that because of the grievance of the petitioner in not being awarded, in not being given 100% of the compensation amount, the issue with regard to the issue with regard to payment of compensation was decided by the Dobashi court by judgment and order dated 10/12/2024, correct? In DB case number 17/2020. The petitioner filed an appeal against the same to the Deputy Commissioner, who endorsed the same to the District Customary Court, Dobashi, for disposal. The District Customary Court, Dobashi, reiterated the decision of the Dobashi Court by the impugned judgment dated judgment and order dated 11/7/2025. As the decision of the District Customary Court which is not in existence, has been done without what have I said? No, it has been done without, without being in excuse form. The said judgment and order is void. Is null and void. Full stop. The said decision, the said appeal of the appellant, a petition shall have to be decided by the concerned deputy commissioner in terms of Rule 31 of the Administration of Justice Rules, 1937. But this is a 2 to 7. Anyway, so I'll convert it first off as the present, due to the above facts, this court converts the present petition under Article 226 of the Constitution to a petition under Article 227 of the Constitution. The impugned judgment order passed by so and so is set aside, and direction for disposal of the appeal by the petitioner is accordingly to be decided by the deputy commissioner. The writ petition is accordingly disposed of.
Flash Morak.
I would like to highlight the court case after the passing hearing. Please to verify there's no coming from it's a private lordship.
Whether it's a proper government or not, that's not.
Whether it is a-
It is not a supplement of the case. So the letter politically that the versus people go according to the procedure. But we should not make something different.
Book which we are referring is a private, it's a private.
Make something different.
You can have.
Make
I was, that is why I was looking because nothing has been said about the comment. If it is comment book, then comment will say that by cassette. But it's a private book.
You please read.
No, I have read that.
Yes,
That's
Your
why.
Lordship, this is a book by Justice Zelray. It's a compilation of the Nagaland 1937 with all the amendments.
You see, these are the types of books we have everywhere. You go to Mizoram, see, you go to Arunachal, similar.
I'm just sharing because judgment has been already marked, but I'm just sharing. But this is this. I'm just sharing.
Huh?
I'm just sharing.
You see, the issue is, the only thing where the Dobashi judgment, the first judgment has not been cancelled. It is still in force. Only the second one is, but the second one is only a reiteration of the first. So there's nothing. So he doesn't get anything till date. Now, in fact, because we set aside this, he has to go fast to the DC asking for a stay.
Obliged, Morak.
Lordship also get one, related. I have been there. So I will give you and the.
Oh, thank you. Please write down a message and your signature also and date. Write down your name, signature and date. Okay. A book regarding what?
That is on he is customary. And since we I would say the custom conditions are almost the same. So I've written on this customary law practices and then applied something about us. So I took around 14 years research on I was really in my other degree. So ultimately I am concerned with the worksheets, I am concerned with district administrators, retired district administrators, politicians, all people, district information, ultimately I covered people. So for your knowledge, I'm just giving one book to do it. Yes, it's after the conference.
Thank you. If I have time this week, you see, I've got to read all your files. Get ready for you all the next day.
Okay, Marshal.
Thank you.
Sincere apology, Lordship, but relating to that case, there's an IA. So if that can be also
I have
dismissed,
to
Lordship.
dispose of
Lordship.
accordingly.
Yes, Lordship.
Your name, I have recorded your name, no?
Yes, Medovero, yes. Applies for.
For hearing, item number 27.
Domestic violence case. I've got a meeting at 3 o'clock. I didn't know. I thought you all will adjourn everything. We can do it tomorrow.
Okay.
No problem.
Tomorrow then, madam. This is not domestic violence, Your Lordship. The short question here is whether the village council
Could summon you.
and dissolve my marriage.
Dissolve your marriage.
Yes. The issue is already covered, Your Lordship. The one from
No,
the.
Can the village council dissolve the marriage?
This has to do with family matters. And so it is customary law applies here. So as per custom, the village council has declared that it's a case of desertion by the wife. That is as simple as that. Even without going to the court, Your Lordship, the customary law is quite clear. As per custom, if a party deserts, then the marriage is dissolved automatically. That is
We'll see.
even without.
We'll see tomorrow.
Your Lordship.
Yes, tomorrow. Only thing we have got to you should keep in mind that all customs are not customary laws.
Yes.
Yes, but when it comes to marriage, divorce and all these are governed by the customary law, as simple as that. Especially inheritance, marriage, all this, it's covered by the customary law.
In fact, Your Lordship, it's a very short matter, and the issues which my learned friend is raising already covered by judicial decisions.
Anyway, we'll decide tomorrow. Right, on the prayer of the parties, list the matter tomorrow. No time, no? I forgot this meeting.